this morning and those who are joining us online. My name is Matlodi Maseko, and I am with the members that will introduce themselves for record purposes and also to welcome our officials from the department, national and the provincial. Members, over to you.
Morning, Chair. Good morning, everyone present. My name is Pet Mahan, member of this committee.
Morning, Chair. Morning, members. Morning, everyone. Mbulela Isaac Saleko.
We can get those who have connected online to introduce themselves.
Good morning, Chairperson, and my name is Jacques Lund from the NCOP side.
Thank you very much, Member in Lund. Officials that are in the house and then after those online.
Morning, Chair. My name is Liwanindo from National Department of Public Works. Thank you.
Morning, members. My name is Pamela Maseko Kambala from the Department of Infrastructure in the province.
Thank you. Officials that are online. We have about 9 people. For record purpose, if you can get Nicholas Diaz, can you introduce yourself, sir?
Hi, good morning, Chair. Nicholas Diaz from the Department of or Legal Services Department of the Premier.
Thank you very much. I think that is all the introductions. And for apologies, Kayla Murray is the, I've received her apology. And from the Department of Infrastructure?
Acting HOD, Chantal Smith also sent in an apology.
Thank you very much. Shimiz, is that all the apologies for today?
Yeah, that's all.
Okay, thank you very much. Members, if you have received the agenda for today, for the whole day, I think we are going to go through the deliberations on metrics of submissions on the expropriation bill, B23B 2020. And we do have about 90 pages that we have to go through for the day. And also to appreciate our representative from the NCOP, Mr. Yako Lund. I don't know if we have any introductory remarks to us or before we start the day with Mr. Ndu in the house to go through the metrics.
Thank you, Honourable Chair. And just firstly, from my side personally, I want to always show my appreciation to the Western Cape Provincial Parliament for taking these bills seriously. Quite a few of the other provinces do not always give the detailed input and considerations as the Western Cape does. So that makes my life a lot easier representing the province in the National Council of Provinces. Also want to apologize a bit, even though it's not just on me, but we are trying to ensure that there's not a rush of legislation coming through at the end. But unfortunately, it seems that there are a higher frequency at this stage, and I know that puts a lot of pressure on the members and the staff there, but I also want to thank you for still being diligent from your side. So we have received in the committee all the inputs from the provinces in the past, from our public hearings. So whatever you decide now and give a mandate to myself, that will then be what I carry in as well. So just that's shortly from my side, but just a word of appreciation for always being so diligent and making sure that there are clear mandates given through that looks after the interest of the province.
Thank you very much, Member Lund. I think from our side also, the challenge that we were facing as we were going through the matrix is the outcry from our communities in Western Cape, which they felt that we didn't do enough public hearings to reach some of the rural areas. Unfortunately, I did communicate with the NCOP, as chair, to maybe give us time until February, looking at the parliamentary program of Western Cape Provincial Parliament to see if we can try to get some days to go and do the public hearing. But unfortunately, only 1 week was given to us, which was the last week. So it's not possible that we would have had a time to go to those rural areas like your Matsikama, the far end towns that the communities felt that that is not, we sort of shortchange them when coming to the public hearings. That's the number one. Number two is, in our negotiating mandate, yes, we are going to make sure that that message from our communities also has to be captured, that not enough public hearings have been done from the allocated time that was given to us as Western Cape. And we usually try to make sure that it has to be all about our communities, that we can hear their voices, so that when we develop our negotiating mandate, we talk to what they are saying about the bill. So that's the unfortunate part, that the time allocated was not enough for us to be able to do that. But we will continue to see if maybe, if we continue to have this conversation, maybe there can be a change of heart to make sure that when the negotiating mandate comes to you, that they say we can go back and do those public hearings. But thank you very much for being with us. I am now going to continue with our agenda and give Mr. Ndu for us to continue. I think we have we are going to start with the Annexa A. Shamis, Emma, on the screen. If you can check on the screen, and then we'll take it from there. Good morning, member. Can you introduce yourself for the record purpose?
Good morning, everybody. I'm Peter de Villiers, and I'm a member of this committee, and couldn't control the traffic today.
Yeah. Thank you very much, honorable member. I'm going to, Mr. Ndu, I'm sorry, I'm going to start with the Department of Infrastructure, because this is the comments from, is it?
Probably a consolidated comments for the Western Cape government as a whole from other departments as well. Nicholas would be the appropriate person, I think. I'm not miscom legal services.
So this is the Western Cape, is the consolidated from all the departments.
Yeah.
Okay, so for the,
So you can brief us on it.
yeah, is it possible for you to brief us, or should we start with Mr. Ndu and then you will do after?
I think the legal services person is here, Nicholas, if I'm not mistaken. He should be the one that does it if it's for the collation.
Mr. Diaz, if you can do the synopsis of this annexure, we'll appreciate that to hear from you.
Chair, this is submitted on behalf of the West Cape government, but the department takes lead. It's signed off by the minister, so the department should be the one to lead you through these comments.
I'm going to make it easy and just go through it.
Okay.
Close by close, and then we will, yeah. Okay, so because I was thinking that both of you already, maybe you have negotiated with each other who will do it. Okay, the first clause on the general comment is it has foreseen that expropriation of land may happen for two reasons: for purpose of public good, B, to rectify the wrongs of the past, whereas the implication of A is that the land will be rezoned, used for another purpose. The implication of B is that the land must still be used for the same purpose. The bill in its current form does not make this distinction, with the result that a piece of land could be expropriated for the purpose of land reform and without going through the proper procedures used for a purpose, example of the housing or industry, different to what it was zoned for. So the suggestion or the amendment or addition is, it is proposed that the bill must explicitly consider the implication on zoning and land use. It is not clear from the bill in the case of the expropriation of land whether if the expropriation is for a purpose other than the current use of the land, the necessary permissions and authorizations, for example, the rezoning or subdivision, will be obtained before registration of the transfer of the land to the expropriating authority. It is proposed that express provision must be made that all authorizations must be obtained prior to the registration of transfer if the land is to be used for a purpose different to its current purpose. Mr. Ndu, any comment?
I think, I'll comment around the issue of proposed express provision, because one would have expected a situation where perhaps, some suggestion actually put forward in terms of actually making it very explicit. So here, I think they're indicating to say that it has to be, it has to have express provision. But, example of that, provision that could actually, put it very explicitly is not actually flagged in a way. So I think, in one way or the other, we need to actually get a clear picture to guide us in terms of what is it that could actually be, flagged. That will actually sell when we engage with other provinces as well, which is expressly going to actually give a clear picture in terms of what they're actually providing here. Chair, let me also indicate that we from the national office, we have formulated a committee of some sort because we got 5 reports last week on Wednesday. I think I spoke to Shines on Friday. So most of the issues that are covered here, they are also covered by other provinces, and we're consolidating the report and also the answers to that effect. For example, I think we'll find the question of defining what do you mean by expropriation, what do you mean by a property, why do you actually use a definition as covered in the constitution of the country. So those are some of the things that we're actually working on, and we have brought the expertise of the senior councillor as well to assist in terms of actually giving some guidance so that we could actually align ourselves with the constitution of the country. I thought, Chair, what we were going to do on the basis of the metrics, I thought perhaps, I was going to be given platform to actually give some, inputs in the process, but which are going to actually, be given comprehensively in the end when we have got, the questions that are coming from Western Cape specifically. But that's what we are working on. We have got a committee in the process to actually give effect to the answers. But we assist here and there, and probably, if possible, before Tuesday, I'll give you the comprehensive what you call report, including the discussion that we actually have on the basis of the questions that we get.
Okay, I think the challenge now, it will be, if we could have received that report, it will help because we have to have the negotiating mandate from the Western Cape. And if we had that report, it will help us also to look at the report that you have as we develop our own negotiating mandate. Now, presently, we have to look at the metrics to make sure we develop the negotiating mandate, which is the voice of the Western Cape communities. And another thing that is sort of now a challenge is the dates, because negotiating mandate date is the 15th. When? Yeah, the 15th. So that's the due date. And the report, if it's coming like by Tuesday and Wednesday is the 15th, there's no alignment for that happening, which now that is why we have to go from clause to clause for us, because tomorrow we have to have the negotiating mandate that we have to send to the NCOP. So that's the challenge. If the date could have been shifted not to submit the negotiating mandate by the 15th, that report would have helped us to make sure that we work with that, to make sure that we try to see if there are issues from the other provinces that we acknowledge that we do have, or any other way that we can make it easy to make sure we talk to the metrics. I saw, okay, thank you very much. Okay, so the second one, it will be the members for the first general comment. Any question, Member Maran?
Chair, I just wanted to check just the wording, the 2 reasons. And when we have started this process, the 2 reasons was either public purpose or public interest. And if you look at B, although it says land reform, it does not specifically, the wording of public interest is not there, unless we are saying it's the same thing. Thanks.
I think when we define public purpose and public interest, we gave an example in terms of the public purpose. We gave an construction of dams and so on and so on, and in public interest we had the countries committed to land reform issues as covered by the constitution. I think from where I'm seated, it's covered. It's just that it's not explicitly expressed, and in one way or the other, is it talking about public purpose or in the public interest.
I just thought, Chair, if you look at B to rectify the wrong, if, for instance, if you look at A, it says for public purpose, and then there's an explanation given. I just thought it should have said public interest, and then also the reason giving, the explanation, say, I land reform. But it's fine. I don't have a problem with that.
Okay, I think that's the right question for us. It's some of the things that we have to note for our negotiating mandate tomorrow when we develop our own negotiating mandate. If we feel there need to be a public interest there, then that's how we go about. So that's you ask the question, why not? And then if the response from Mr. Nu doesn't augur well with you, that you feel that it's where the negotiating mandate has to include to what we feel that it will be the right way to being used for B or for A and for that. Okay. Thank you very much. We are going to continue. The next one is throughout the text reference is made to time periods calculated in days. Clarity is required on whether the periods refer to calendar or working days. Mr. Ndu, on the suggestion is clarity must be provided. Your opinion?
Chair, normally we refer to the working days, not the calendar days. And what necessitated us to actually refer to the working days is that there are holidays and also the December period for the expropriation bill is not actually factored in. That's why there were issues, in terms of us gazetting it. I think we gazetted it on the first week of December in the first time, and that did not actually augur well with the entire country to say that why are we actually gazetting it around December period when people are on holidays? And why don't we also consider avoiding the holidays, because when there are holidays, people tend to actually, focus on other things. So in this context, we're talking about the working days and excluding all the holidays and the December month. So in one way or the other, in this bill specifically, holidays are excluded and weekends are also excluded in the process we talk about the working days. Perhaps, when we negotiate, we might actually have a different view, but in the bill, in its totality, we're talking about the working days.
We continue. The third is the period referred to in clause 2 of 2B, 20 December to 7 January, may be problematic as many businesses close on 15th December, the day before the public holiday, which is the reconciliation day. And many people take annual vacation leave as from the day following the public holiday. It is proposed that the period is reworded as 5th December to 7th January. Mr. Ndu?
Chairperson, I think it covers the issue that I was raising to say that we must be very careful around the December period, and therefore we try to do away with that period on the basis of the comments that we got as well when we gazetting it for the first time. So I'm inclined to actually support that statement that has been put there to say that we must be very wary of the December period. Perhaps, yes, they spoke about also the public holiday. They must not specify the 16th one. Any other activities during the course of the year, that also cut across the public holiday as well. It should be considered by the bill. Like, for example, if you serve a notice of expropriation on the 7th of April, and it's a Good Friday for argument's sake, you might find that family A is not there, and therefore the notice has been served, or something happens in the process and they don't get that. So I think the holiday in totality we should actually do away with them, and that could be our proposal, and see how best we can achieve.
Thank you very much. And the clause 1, it is suggested that any reference to departments in the bill should also include the relevant provincial department if appropriate in a particular instance.
Chairperson, I think also the bill, remember when we talk about the organs of state that have expropriating powers, we spoke about province, municipalities, and also the National Department of Public Works to say that these are the organs of state. These are the department that have got powers and they use their own pieces of legislation to expropriate. So perhaps to be explicit here and talk about provincial, it might actually create, some questions as well to say why are we not also flagging the municipality? Because when we're saying expropriating authority, we're including all organs of state that have got pieces of legislation to expropriate. But from where I'm seated, whether we say relevant, provincial department, relevant municipalities, to me, it's like repeating what we have said, because they've got powers to expropriate. They are included as part of the expropriating authority.
Mr. Diaz? A comment from you?
Yes, Chair. In regards to specific legal comments, I can speak to and assist. So the question here is whether that word department, as it is defined with a capital D, is going to unduly constrain the best application of these clauses which we've cited, clauses 4, 5B, and 24(2). And it's simply saying that if it retains its definition as it is now, that is only the national department, then the provincial departments won't have the benefit of those clauses. So that is the thrust of the comment.
Thank you very much, Mr. Ndu.
I think I understand the context. It's fine. We can actually leave it like that and see when we negotiate. It's fine. It's fine from where I'm seated. But I was just flagging to say that, remember, they are also included as well when we define the organs of state and also the expropriating authority. We can leave it like that and see how it goes when we go to the second stage.
Thank you very much. Members? Covered. Okay. Okay, so in the definition of court, it is clear that the disputes envisaged in clause 21, which relate to the application of the bill and which will be capable of court determination, may likely constitute administrative action as envisaged in the Promotion of Administrative Justice Act 2000, which is the PAJA. The definition for court in section 1 of PAJA provides that a court includes a magistrate's court, either generally or in respect of a specified class of administrative actions. This designated by the minister by notice in the Gazette and presided over by a magistrate or an additional magistrate designated in terms of section 9A of the Act. The definition in PAJA is broader than the draft definition for court in the bill. The draft definition read with clause 21 restricts the access a disputing party has to a court, in that the draft definition provides for a magistrate's court within whose area of jurisdiction the property is situated. By way of example, a disputing party may therefore not approach a magistrate court other than the one where the property is situated, except in the case of intangible property provided for in paragraph C of the draft definition, and even in the case of paragraph C, that is limited to the magistrate's court within whose area of jurisdiction the owner is ordinarily resident. The draft definition is therefore not aligned with PAJA. A deviation from PAJA is only permissible in terms of section 3, 4, and 5 of that Act in relation to fair process and reasons for decisions. It is submitted that the range of jurisdiction of magistrates' courts in relation to administrative justice as provided for in PAJA must be incorporated in the draft definition for a court in the bill. Furthermore, the draft definition assumes in relation to the magistrates' courts where the property is situated, that both the presiding magistrates and the court has been duly trained and designated respectively, in accordance with section 9A of PAJA. Practically, this may not be the case, and then it will not be clear to which court a dispute in terms of clause 21 may be referred. Paragraph C of the draft definition is confusing. Does intangible property include intellectual property and unregistered rights in immovable property? If so, then in the case of the latter, those rights would fall under paragraph A or B of the definition. This confusion may lead to forum shopping. And the suggestion is, it is proposed that the draft definition for court is aligned fully with the definition for court in section 1 of PAJA. Mr. Ndu?
Chairperson, I think the proposal is one of the things that we're looking at now. It's in relation, remember I said we are working on a report and we have identified about 11 thematic areas. One is the issue of definition, and this is one of the issues that we're looking at as well, to define courts in line with PAJA and see how best we can include some of the elements that are not actually covered as per draft definition as it stands. So I think I agree with what has been flagged here, and we need to really look into that angle and see how best we can actually align it with what has been covered by PAJA.
According to the draft
Chair-
definition, okay.
Chair, my apologies. This is Nicholas from Department of the Premier speaking. I just want to check if these comments are the ones that were submitted this year, or whether these are the previous ones that were submitted on the prior set. These seem. I'm just concerned that these are the outdated ones. The latest ones were submitted. It should be indicated on the first page of the comments. It should say comments on the expropriation bill, comment 2023.
Okay, let me find out from my procedural officer which one is this. When did you see?
Ones we're going through now are dated 2021 and were signed by the Premier. Hence, I was saying that I can't go through them. And then there's also a comparative document done by Legal Services comparing the first ones we did in 2021 and the last ones. And I've got that here, the submission.
Mr. Diaz, thank you very much. We don't have the recent one. It wasn't sent to the committee. The one that we have is the 2021. That's the last one that we received.
It could have gone lost with the cyber attack.
Yeah.
If you could flag that.
Is it possible if you can flag that with us, then we can look at that?
Chair, sure. Just 1 second. Let me see if I have. Perhaps let me first start by finding. I do have the email with confirmation proof of delivery to the chairperson's office, and that was sent on the 30th of June 2023. So the comments were sent to sjones@wcpp.gov.za, 30th of June. 30th of June 2023.
So a lot of this we don't have
And-
anything.
Yeah, unfortunately, during the cyber attack, there are some documents that were lost. So it might be one of those because we
don't have it because I collect.
Yeah, we don't have. Member Mara?
I'm just saying, Chair, I've seen that letter some time ago, the one from the Premier's office. Oh, but I saw the one that's dated 2021.
Yes, this is the one that we working.
Okay, I will see.
The one we are working on, members, is a 2021.
Yes.
So Mr. Just is saying that there is the other one after the 2021, the recent one. So if there is, I was saying, if he can flight it, then we don't have to go through the 2021. We will look at the recent one that.
Or you can email to me.
Or you can email it to Shumis if you have her email, and then
Chair,
she
I'm
will
happy to do that. I'm
Okay.
happy to do that. Let me then forward it to The same email that was indicated, sjones@wcp.
Yes, that's the one.
I'll send it through right now. Thank you.
Okay, thank you very much. In the meantime, and then also Shamiz will send to Mr. Ndu, and then you can be able to, but anyway, even also it will be on the screen, but she will send it to you. You have?
Just looking at I think it's a 6-page, if I'm not mistaken, summary from Nicholas of the difference between the last one comments and the 2023 one. I'm not sure if that helps the process for today.
There are some, and then others are not included in that. So it will take me time to check which ones are included, which one were excluded. So it's better if we go through this because everything is in here. And okay. So we've got the hard copy here, Mr. Diaz, but still we feel because as I look at the 6 pages, it excludes some of the issues that were talked to for the 2021.
Yes, Chair, the comparison document was not meant to include comments, just to identify for purposes of developing the comments. The comments themselves will be very different. I have sent through 2 emails to Ms. Jones. So Ms. Jones, please, if you could just see if you received my first one, that should have the annexures.
So that is an extra C. Okay, members, just bear with me, Mr. Ndu, just bear with me too. Is the 2023 one?
Yeah, this is the one I just received.
Okay, let's have a look at the 2023 one. For the part A, the property rights. The property rights and the institution that support them have a first order effect on long run economic growth, investment and financial development, and any legislative or policy instrument impacting on property rights should be approached with extreme circumspection and careful consideration of both intended and unintended consequences. And 2, in recent study conducted by academics from the University of Pretoria and Johannesburg, Dr. Rulo Botha and Professor Ilse Botha, the following findings were made regarding the land expropriation. Countries that implemented similar policies experienced a decline at an average of 13.9% in their ratio of capital formation GDP. A similar trend can be predicted for South Africa. The authors, in fact, sketch various scenarios in this regard. In one such scenario, it is anticipated that the annualized nominal GDP in Q3 of 2020 will be 270.4 billion. I'm sorry, I just want to look at something. I think we can use this when we are done because this doesn't go for clause to clause. And whereas now we need to go through clause to clause, this is the comments of when we are done going through the clause to clause for the negotiating mandate.
Continue with this.
Yeah, so we members, I'm all yours. Be with me. Because be with me. Okay. So we've got what our state attorney is saying, advisor. This is the document that he was talking about, but it doesn't go to clause like we have to do when we develop our negotiating mandate, of which the 2021 talks to the clause to clause. Because when we do the negotiating mandate, we have to give the talking to a clause to clause, not just put the general. After we are done with that is where we can come up with the reasons why we support or we don't support at the end. But when we develop the negotiating mandate, we also have to talk to the clause. So my suggestion is we go through the 2021 because it talks to clause, and then after we can look at this document. I don't know if you are in agreement. Or also, Mr. Diaz, I see your hand before the members.
Thank you, Chair. My apologies. Just to point out at page 6, it begins with the clause to clause, and the comments are very similar to the 2021, but they are different in various ways. But from page 6, you'll see it's very similar to the 2021 in structure. The top sections before that are general comments, and then from page 6 onwards are specific comments.
Thank you very much for your guidance, because it's difficult when you're meeting and read quickly. So I see okay. We can start from 6 and then we can use this one. It has 38 pages. This one had 34 pages. So we'll go to the 38 pages one, but bear the first pages until 5 pages. We are not looking at them. We are going to look at the other pages, of which I have to try to. Is your laptop screen touch screen or not?
Yes, it's touchscreen.
Okay. But it doesn't agree with me. I'm sorry about that. So that we are done with the court, the definition of court. And she means I can't work with this. It's better if I have the page.
The hard copy.
The hard copy.
Wait, I connect.
With me. Okay. Okay. We are done with this one. Bear with me, members. And clause 1, we did the clause 1. The department, we just dealt with the clause 1. We are now on the definition of the date of. We did the definition, Mr. Ndu? Definition of the date of, no, we were busy with the date of expropriation. Okay, the draft, so I have to follow this the way it appears. On the page 9, it is suggested that any reference to department in bill should also include the relevant provincial department. So we dealt with that one.
Yes.
Okay, so we are on the draft definition of property. Okay, so the draft definition simply defines property as property contemplated. Mr. Ndu, can I not read the whole thing and just go to the suggested? Okay.
I think it's proper. It's fine. We can do it like that because what is captured there is what is in the. We can do it like that. Thanks.
Thank you very much. So the suggestion when coming to the definition of property is, it is proposed that the draft definition of property is reconsidered to provide clearly and unambiguously what property will fall within the ambit of the draft bill.
Chairperson, I think, as we move along, consulting, that was a question which was raised to say that our definition is quite broad because we're just taking it from the constitution of the country. And from where we seated, we try to justify it to say that, remember, the constitution is the supreme law of the country, and anything that is done outside of the law of the country, which is supreme, it's unconstitutional. That's why we took the definition the way it is. But we agree with it because it's coming across all the provinces of our country to say that at least let's try to revisit the definition of the property and see how best we can define it. Maybe narrow it down and be very specific. What is it that we're referring to when we talk about the property? Because others were talking about the intellectual property and say, is it covered as part of this definition that we've put here? So for me, it's a substantive vertical issue that has been raised. We have to look into that and see how best we can define property according to this bill. But our definition is in line with the constitution of the country. It's in the broadest way, and it doesn't give us a clear picture what are we referring to in terms of what the property.
Thank you very much. Members? Member Ma, your mic is on. Do you want to talk to?
The definition is on page 3.
Okay.
Yeah. Chair, I'm sitting here and I'm just I don't know. These are comments and there is no commitment. And I think and the member from the NCOP is also listening. And you know, I'm just trying to understand, you know, because Mosondo cannot make a commitment and say, okay, no, okay, we are going to change, we are going to agree to you, we are going to adhere to what you are saying. That is a process that will be taken into the NCOP when they deal with the bill. Then they would say, you know, because one would appreciate it if maybe the department has received these comments prior and we're able to deal with some of the issues to say, okay, at least now we are able, when it goes through the NCOP, and those we were not able to, you know, to agree to, and then we're able to get the support of other provinces and maybe push the department. But yeah, but I think for us, Chair, is basically just to really just say, okay, these are the concerns from the side of the Western Cape, and our permanent delegate is also in the meeting, will also take note of the concerns of the Western Cape. And I know that the department will have to deal with them. And then when they deal with the negotiating mandate, then they will have to say, okay, these were the comments from the department, from the side of the Western Cape. This is the, this is the ones that we're able to change, and these are the ones which we're not able to change. Because I'm just because we've got about annexure A until G, and all of them are going to basically be saying some of those things that is been raised here. And then you go to individuals, which is about 92 pages, that is also going to say that. But there is no commitment that we are going to get from the department today that says, okay, we are here. The department can just say, we take note. It goes to the NCOP. What happens then? Because what the official will do will just convey to the department, and the department's legal people will say, we don't agree with the Western Cape, and we'll just take it aside, and then it will go its own processes in the NCOP. So, but it's my first dealing with this from the side of the NCOP, so I don't know how you as WCPB deal with these matters, but I'm more comfortable in knowing that when it comes to the NCOP, the department would actually give us responses and say, this is what we received from the Western Cape, and they will list all the provinces that actually made a similar comment on a particular clause, and they will say, okay, this is what we have able to change. And then in committee will actually say, okay, we agree or we don't agree. And those that abstain will abstain. And then, because at the end of the day, there will be more members in committee that will go for a particular clause. And ultimately, the committee report will be adopted regardless of what other provinces are saying in terms of the different clauses and definition. Yeah, but I just thought, I should just raise that. I hope it will assist us going forward. I'm not sure. Thank you, Chair.
Thank you very much. I think the idea is what we are doing today is exactly that, to try to have an influence on the changes that we would want to see in the bill itself. And I think the issue of property will come again and again because the PI Act has taught us a lesson that has created the land invasion, and PI Act is sort of giving power to the land invasion, that when we say property now, we have to be clear on what do we mean, because the Constitution protects it, criminality one way or another. The intention was not for land invasion, it was for something else, but it has allowed that to happen, that even when you go to court, the court says that go back is the bill that you created there. So it's responsibilities with us to change before the court can rule otherwise. So we in a way, we are saying we cannot take it for granted and say the Constitution is saying that, because interpretation sometimes means something rather than what is on the paper. And the Constitution, we respect it. It's a brilliant Constitution, but the legislations that we introduce are the ones that somehow we shortchange the intention in the way of interpretation from one person to another. That immediately when we introduce a legislation, interpretation has to be understandable to every reader to make sure that we don't have the scenarios of having to argue about what do we mean. So the property has to be clear. What is it that we are expropriating? And it should be clear that I'm not going to interpret it different from Member Maran. Member Maran wants to expropriate my shop, and then Member Silek wants to expropriate my house. And then if you expropriate the house and the business, do you pay me for compensation? Will be the business and the loss and the everything that has, and the customers and the everything that is attached to the business. So it has to be clear so that the compensation to talk to that. Member Maran?
Chair, thanks very much, Chair. And I think if you look at the Constitution, Section 25, it reads property clause. It doesn't read anything else. It reads property, and property is not only land. It can be other things. I remember in Beaufort West with the public hearing, a young girl, she came to the front and said, even there, that as a young person who have a business, does it mean that my business can also be expropriated? And I don't think that's basically the issue, but the Constitution is broad. It speaks about property. If we don't define specifically what property means within the 1975 expropriation bill, you still have the courts who can say, but Section 25, when you have expropriated a business, that could say no, but that's not what we have meant. You still have the option of going to court, whether it's a constitutional court, by saying, although the Constitution is saying property, in my understanding, I don't regard a business as property. Government wants to expropriate my business, and therefore you still got the courts to contest whatever government wants to expropriate. Yeah.
Okay. Mr. Do you want to comment?
Thank you, Chair. I wanted to comment. I think, the input that has been put forward by Honorable Member there, it's making sense. That's the whole intention of this exercise. Remember, you move around the district and areas across the province, and you got input from the communities in terms of what they want to see in the bill itself. So this is a stage of processing those inputs that you actually got, so that when you consolidate your own negotiating mandate, it's informed by those. That's why, for me, it's difficult to actually make commitment now. Remember, we're going to actually have engagement on the 24th, and that engagement is going to be informed by the reports that is coming from Western Cape, Gauteng, and so on and so on. So in terms of the definition of property, public paper, all those things, they are coming. So we have a committee also guided by the senior councillor to formulate responses. They will form the basis of our engagement in the process. Yes, it's true, Honorable Member, around the question of the property. We defining it as captured by the Constitution, and which is very broad. But I think, when we engage, maybe we might be wanting to say that let's try to be very specific. And if we agree, then we'll actually develop a new definition altogether. As it stands, it's defined as the Constitution of the country.
Thank you very much. Yeah, member.
No, I'm trying to listen. I'm listening to what my friend is saying in terms of the definition in the Constitution of property. So, and I always have this in mind that our Constitution is one of the youngest constitutions in the world, and it does not. There is a possibility that, in terms of the definition of property in the Constitution, that it might not be sufficient to define. There is a possibility. So I just wanted to ask, is there a possibility that as much it is defined in the Constitution, but that it might not be vague, it might not be, including some other properties, because property, like, this is property. This is property. This is property. But if you look at it in terms of how it's defined in the Constitution, if you don't go in deep, you don't dive in deep, you might not perceive this as a property. But I'm just saying that I think that's what I'm saying, that as much as the definition is in the Constitution, one shouldn't be just say it is there, it's finished and clear. It might be, that, it a simpler way of defining what property is would be something of, Chair, that one would have to look at so that there is no confusion. Because a car is also property. My jacket is my property. My spectacles is my property. If Pet wants to expropriate my spectacles, and he's going to say it is written in the Constitution, and then he would be able to get access to do that. So I think those are the kind of things that we need to be very, it must be plain, and so that everybody understands. And I understand also the issue of litigation, Chair. I think that is something that also came out during our public hearings, where people are saying, okay, remember now if the state wants to defend its stance, they can do that. But Umbulelo, who does not have the resources, what are we saying about him? How I am going to take on the state who's got more resources than me as an individual? As much the provision is there that you can take it to court. Court is not just there. You need to get someone must pay for this thing. And those are just the kind of issues one needs to be very. So once there's clearer definitions, it limits the chances of litigation. I think that's my simplest way of understanding it. Thank you, Chair.
I just want to check the 1975 Act that we are currently dealing. In there, does it specifically specify which property can be expropriated? And if not, does it mean even if we don't agree to the amendments of this bill, his spectacles can still be expropriated according to the 1975 Act?
Chairperson, I wanted to say that, remember, this is a principal act, and then you develop regulations as well, and regulation give guidance in terms of how you implement the principal act. So the issue that was raising there in terms of actually going to the nuts and bolts of defining what we mean by property, I was thinking to say that when we negotiate, we have to flag that to say that regulation should be very explicit, because they'll be guiding in terms of the implementation. So this is just a broad principal act, which is defining, property as per constitution of the country. But regulation should actually give guidance in terms of what is it that we mean when we're saying a property. Remember, there's an issue about intellectual property as well, which we're saying, is it included when we're actually talking about this property that we're talking about? So from where I'm seated, I think if it's going as per constitution, our argument should be that the regulation should be very explicit, and it should be on record in terms of this negotiation mandate that we're actually talking about, to say when we get into the implementation part of it, which will be covered by the regulations themselves, we have to be very definite and explicit. I thought, because those are some of the suggestions that were actually coming in from our side, Chair, we were agreeing with them, because also the 1975, there are implementation guidelines that are followed, and they give, effect to be very, very explicit in terms of what is it that we're referring to. So yes, property, according to 1975, they're clear, guidance in terms of what is it that could actually be expropriated or not. So I think, from where we seated, that's what we need to give guidance in terms of what is it that we're referring to by property, public interest, public purpose, so that all of us could actually move from the same page, and that can be covered by regulation. Thanks, Chair.
Thanks, Chair. Just to maybe complicate things even more, in the last meeting that we had, there's the talk of property, and the assumption with that is that property is owned by someone. But someone, I think it was one of the members made, and we made the point as a department that there are properties that are not owned. And I think you used the concept of waqf, or it's a Islam kind of interpretation, where there are properties that are there but do belong to God, basically. So even in the definition and as you deliberate in the committee, I think it's very important to not to belabor the point, to clarify that you will encounter also properties that are not owned by people, and expropriation in that context needs to be clarified too. And
Chairperson, I think, the issue of covering registered and unregistered rights was attempting to actually deal with this thing of property, which, some of them do not actually have ownership. So as much as, I'm noting what she's saying to say that we must take that into consideration, but I think, there's an element that has been covered in the bill talking about unregistered rights. From where I'm seated, I think, it's just an ownerless property in any way. And therefore, we need to actually find the best way of how best we can actually deal with that. But it's point noted, and I think, you're correct to say that, you were trying to actually problematize it further.
Thank you. Mr. Diaz?
Nothing needed from us at the moment, Chair.
Okay, thank you very much. Members, we are going to continue on the draft definition of the public interest. It is proposed that the draft definition of public interest is reconsidered and redrafted. And the comment is, maybe if I can jump to the definition, should also not be constrained to a repetition of the public interest mentioned in Constitution, which are clearly provided as examples and not as a closed list. The definition should thus consider and include other public interests of greater relevance in urban areas, such as overcoming the legacy of special dynamic associated with apartheid town planning, the provision of facilities near to affected communities, and increasing the provision of affordable and subsidized housing. And like I said, the comment is, it is proposed that the draft definition of public interest is reconsidered and redrafted. Mr. Ndu?
Chairperson, I think the bill talks about the court as the final arbiter in terms of making some determination covered in the bill. So I thought, when they're saying we should redraft, and where we have indicated to say that that's not limited to the example that are given there when we define, and therefore we reflected to say that the court should be given the latitude to actually make a final determination in terms of what amounts to public interest, what amounts to public purpose. Although I hear what they're saying to say that at times, if you leave it broadly like that, it's subject to be abused and so on and so on. But from where I'm seated, I think the way we have defined it, and also giving the court the final status to be the final arbiter, it's fine enough. Because they just say we should redraft, and one would have expected them to have given a bit of an example of how we can redraft it to include what they think is missing. Because we thought when we're using the Constitution is broad enough, and therefore we also given the court the final hand to make a final determination.
Mr. Diaz?
Chair, perhaps just to say that the comment does give some examples of what could perhaps be included in a definition if defined. That's the last paragraph. And I would just point to Member Marais' comments about the fact that a court will only deal with an issue retrospectively, whereas obviously if legislation up front tells you what something means, the public can more easily guide their behavior rather than waiting for the court to clarify. Having said that, I appreciate the comment that it's difficult to make definitions of these things. Yes, thank you, Chair.
I think, because if you talk about the spatial town planning, and in the bill, we talk about the issue of land reform, which in one way or the other includes the issue of the spatial, planning. Because the thing is that, when we say functionary, the organs of state that have got pieces of legislation that deals with human settlement, and in the main, when you want to integrate and disintegrate the legacies of the past, that's true to understand this part of land reform. And therefore, the zooming specifically and flag it in the Principal Act, I don't think, because you'll find that our bill is going to be 1,000 pages, because we will need to actually pin to the specifics, on a number of aspects. But I hear what they're saying, but I thought they are actually covered by the question of the land reform, and also human settlement using their own pieces of legislation to expropriate for human settlement purposes. They will actually include, like when we say expropriating, you need to actually include all the parties, your planners, your town planners, and so on and so on. So those elements are going to actually come in the process, and therefore the integration and dealing with the legacy of the past is going to be part of that as well. But I don't know whether we have to be very, very explicit on every part of the bill, instead of leaving it in a very, very broader way that will actually include other elements that might not actually find expression on the Principal Act. Thank you, Chairperson.
Members? Okay, you don't have a comment on the public interest. Okay, let's continue on the draft definition of public purpose. The suggestion is it is proposed that the draft definition of public purpose is reconsidered and redrafted again. And maybe if I can quickly read, the definition of a public purpose reflects that seen in the Expropriation Act 1975 with the added caveat, and I quote, in terms of which the property concerned will be used by or for the benefit of the public, close quote. The retention of the phrase any purpose is problematic. Despite the caveat, this definition is overbroad. It is defined to include any purposes, so long as the end outcome of the expropriation is that the property will benefit the public. In the Livingston case, the Constitutional Court held that the exercise of public power must be done in pursuit of a legitimate government purpose. In the FNB case, the Constitutional Court highlighted that Section 25 of the Constitution dictates that no deprivation could be arbitrary. This requires more than merely rationality in the ordinary sense of a rational connection of an acceptable means and ends. It entails having regard to the relationship between the purpose of the deprivation and the person whose property rights are affected. In the expropriations, when all the rights of the ownership are taken, even more is required. The test is one akin to the proportionality test in Section 36 of the Constitution. This requires a careful balancing exercise that compares the impact on the right of the individual to the persuasiveness of the societal or state, or the state interest. In these circumstances, any purpose by an organ of state will clearly not suffice. It should, at the very least, be any reasonable and justifiable purpose.
Chairperson, maybe the last statement today, who makes the final determination in terms of what is reasonable and justifiable? So it goes back to the question of the court that we're talking about, to say that in our bill, we say the court should be a final arbiter in terms of actually justifying some of the issues that are covered, particularly in relation to reasonableness and justifiable purposes. So yes, the comment is noted, and yes, like, the public interest, we need to actually look into that and see as to whether we can actually redraft and have a better definition. But I'm saying we're using the Constitution in the process, and therefore we have given the court as the final arbiter in a way to make a final determination. And the question of justifiable and reasonable, we leave it at the hands of the court.
Members Leku?
Chair, I see the court is going to be very busy, and our courts already have a backlog, so, and I'm just a little bit worried, and I think really our plea is to just, in terms of the definitions, is to really come to a level of making it more understandable to everybody. As much as there's an opportunity for you to go to court as the final say, and because we are, at the end of the day, there are those that can afford, there are those that cannot afford. And I think because I speak on behalf of those who does not have any idea of what the law says. If they're going to be, disadvantaged by a particular bill, and one says and try to justify why there won't be any better definition, is because the court will be the arbiter that says, what is a public purpose, and public interest. And I'm a little bit worried, Chair, honestly, because we cannot leave it for the courts to say the court will be the first, the last, and the last, because it's money, and the judiciary got their own issues that they are dealing with. They already have a backlog. Now we are bringing a law that is going to add another backlog onto them. I'm just a little bit worried about some of the issues that we need to show to. Yeah, just my.
Thank you very much. And I remember the public hearing, there was a submission of who's going to pay for legal fees, already anticipation from our communities that they will be going to court a lot. And they wanted to put that the government has to take responsibility of the bill because it's their legislation. Mr. Ndu?
Chairperson, maybe to put us on ease in terms of this court that we're referring to, I think that there was a suggestion not so long. There's a long court bill, because the issue was to say that there should be dedicated courts that are actually dealing specifically with the land matters. And then in our suggestion as well, I think at the IMC level, we said, we should tap in terms of that particular provision where the land matters are going to be actually dealt with your restitution, distribution, and so on and so on. It's not the, the ordinary courts that have got bad luck. This one will be specifically focusing on the land matters. And yes, the issue of access to courts as well, I think it came strongly to say those who have got access to resources might be the one benefiting. And then if we're talking about the question of land reform and therefore wanting to actually deal with the legacies of the past, how do we then actually use the court as the final arbiter because there are resources involved? We were thinking to say that there should be specific resources to actually deal with the particular elements of the bill. Like, for example, the issue of the land reform. Specifically, there should be dedicated personnel to actually look at that particular matter, but arising from the land courts. And I think there's a bill to that effect that is actually going on as we speak. Chairperson, some of the things, remember the process issue that we've actually flagged. We spoke about the arbitration. Before you could actually go to the court, you would have actually engaged. And there's no money involved in terms of that arbitration that we're talking about, where there are disputes, where there are issues that perhaps they're not actually resonating well in terms of what you're intending to do. So when we say in court, that's the last stage after you've exhausted all the processes. And also, take into consideration this suggested court that we're talking about that are going to be dedicated to deal with the land matters. But anyway, remember, it's just in the embryonic stage. You're still going to actually engage and see how best you can actually get out of this matter. Thank you.
Member Maran?
Chair, thanks very much, and I'm happy with that response. The court should be the final arbiter, but also explain there will be a process basically and see whether we can find it. And only when there's differences and you cannot find each other, only then will the courts come at play My colleague raised the issue of the courts, and I was saying to him now, Chair, in 1975, when this act came to effect, Chair, those who've been deprived of that land, of their land or their property, then did not have the courts to their advantage, nor did they have the money, if there was a court, to go to court. This process basically, Chair, is to correct the wrongs of the past. There will be mistakes made through this process, but no process ever was perfect. But at least, Chair, and many times we are saying the Constitution is the best. Our Constitution is the best in the country. If we can't find each other, then let the best court be the final arbiter in terms of differences that will be there. Thanks.
Thank you very much, members. Let's concentrate on this. Tomorrow we can give you a lot of time to talk to them. If we can look at the metrics before us and comment on them, so that we still are on a section, now is a C, and we still have 90 something pages that we have to go through. So I'm not going to stop you from talking, but I just have to make sure that you keep that in mind, that that's what we are doing for today. So we are going to continue. Mr. Diaz, don't forget to raise a hand if you want to comment.
Thank you, Chair. Perhaps I should just quickly say, I'm only meant to, my only role and my only authorized role is to assist with technical legal comments. And so far, the questions that have been asked have been technical legal, so that's my input. But for anything on policy related comments, Chair, if there's a questions on those, they should be directed to the department. Thank you.
Thank you very much. But on some, because this is a compile, the annexure that we are dealing with is what comes from all the departments in the Western Cape government. So the comment of Mr. Ndu, maybe if it's not aligned to what is here, I tend to believe that maybe you have to come in to maybe give them more clarity for him to hear what is the rationale behind the suggestion on the comments that is made from the Western Cape government. But I hear you, that hence I'm saying that if there's anything, maybe you can raise a hand as you continue listening. Okay, next is the clause 3.2 of B. Because of the public benefits, which is the general comment, because of the public benefit that the areas mentioned in this subclause generate in order to safeguard land, which is important from a biodiversity or ecological perspective, the state often engages with the landowners in order for them to protect the biodiversity and ecology in question. This clause might give property owners the impression that discussions around safeguarding portions of their property in the public interest could lead to expropriation. And then the comment is, given the concerns raised above regarding the definition of public purpose and public interest, it is proposed that guidance or clarity is provided on when organs of state may rely on this clause to distinguish engagement with landowners regarding expropriation from engagement that relates to, for example, the protection of biodiversity and ecology. Mr. Ndu.
Chairperson, I'm glad because they're talking about guidance, and I've reflected to say that this is a principal act. And then when we go to regulations, guidance should be very explicit, and we know, it will give a clear picture in terms of how this can be addressed and how expropriation should be carried in that regard. So again, I think although they haven't actually flagged that, but when they're talking about guidance, I think that guidance is going to be provided by the regulations when we implement the Expropriation Act specifically.
Sorry, partial expropriation of a property should be subject to appropriate subdivision and land use, as well as legislation regulating land use planning and management. The proposal is that provision is made that partial expropriation will be subject to legislation regulating land use planning and management. Mr. Ndu?
Chair, again, because I think it's a question of cross-referring, and I think, we have consulted the issue of SPLUMA when we're actually developing this bill. And for them to reflect to say that we must be also subject this to the legislation regulating the land use planning and management. One would be saying, when we deal with bilateral, we deal with SPLUMA, we dealt with I think there were about 4 elements that we have actually dealt with. This is also included. This is also covered there as well, because we cross-refer. We don't actually, leave that in isolation. So I would say it's noted, and I think, we have considered that as well when we're developing it.
Thank you. I don't see any hand or that for comment. I'm going to continue to clause 4. Clause 4.2 provides that the minister may not delegate or assign the powers or duties conferred on the minister in terms of clause 3 of 21 and 21.1 in the bill. The municipalities are by design better placed to identify the needs of the community for land reform. It is submitted that in addressing the issue of land reform, the bill must employ the principle of subsidiarity. The proposal is that clause 4 must be reconsidered to expressly provide that the powers of the minister in clause 3, 21 and 21.1 must be capable of delegation and assignment to municipalities. Mr. Ndu?
Chairperson, you see, the thing is that in terms of the powers of the minister there, we said the powers of the ministers are restricted only to the public works function. I think that's what we've actually flagged there in the bill. And then we said other organs of state that have got the powers to expropriate as well. They should actually use that, but cross-refer to this because this is an overarching. So I would say, yes, we note that, we'll see how best to find expression, but we have defined the powers of the ministers in the bill and will restricted that to a particular function.
Thank you. Mr. Diaz?
Nothing from us, Chair.
To clarify something, Mr. Ndu, if I understand it correctly, provincial departments dealing with human settlements don't have the power to expropriate, right? So in this context, the national minister would delegate to the municipalities? Is that what you implying?
Not necessarily. When you don't have powers to expropriate, remember you ask the national minister to actually expropriate on your behalf. You see, we talk in terms of the organs of states that have got powers. If you don't, then you actually go to the minister and ask the minister to expropriate on behalf of you.
Okay, members? Okay, I'm going to continue. Clause 5.2a, figure 3 and 4, subparagraphs 3 and 4 of clause 5.2a provide that the expropriating authority may, in writing, authorize a person to dig or bore on or into the land and construct or maintain a measuring weir in any river or stream, respectively. Given that these activities may be subject to, for example, the National Environmental Management Act 1989, which is NEMA, and CEMA's, consideration should be given to expressly provide that all other legislative requirements would still be applicable to such activities. And the command is, the proposal is that clause 5.2 is amended as follows. Subject to subsection 3 and any other applicable legislation if the property is land, an expropriating authority may, in writing, and then you continue with the clause. Over to you, Mr. Ndu.
Chair, I think, I would say I've noted this because they're explicit here. They're saying if the property is land, you see, they're trying to qualify it further in the context of land. And therefore, they are leaving the other, properties in this context. So one would say, yes, we are noting the proposal. Let's throw it on the table and see as to whether it doesn't actually fly when we're doing our negotiating the final one. I'm noting that I'm amenable to that.
Okay, I'm going to take it in the consultation where you are doing the report. This is not one of them that you noted.
We haven't actually finalized. I don't know, maybe it might be there, but from where I'm seated noting, then it will actually find expression on that as well.
Okay, thank you very much. Clause 5 4D, paragraph 4 of the memorandum on the objects of the bill does not indicate whether SALGA was specifically consulted on the development of the bill.
Chairperson, SALGA was comprehensively, consulted in the IMC. There's a representation of SALGA. We have, and I think, also they've made contribution as part of the 50,000 comments that we actually got. So maybe, if there are different structures, at SALGA and others are not aware, but we have consulted with them and they've made contribution. Thank you.
Thank you very much. Clause 5 4D 3. The comment is the request for information should also include relevant authorizations required in terms of NEMA and SEMAS. Okay, it's noted. Members? Okay, clause 5B, clarity is required on whether consultation would also not be required in respect of a right in land. The clause 5B. You have that.
Chairperson, the bill talks about all relevant, stakeholders, all affected people. So therefore, I think, that also cover that particular element because all the people affected by the property in question should be consulted and all the relevant stakeholders as well should be consulted. So if they're saying consultation in terms of the right of the land, for me, we have actually put a generic statement that includes everybody.
Between Mr. Diaz and Ms. Pamela, who can give us clarity to that clause, that comment? The clause 5B of the clarity is required on whether consultation would also not be required in respect of a right inland.
Just reading the bill itself, and that specific clause only, I think it's again an interpretation issue of property because here it's specifically talking as if it's relating to land. So I think the question is when it's not relating to land, what processes then would be followed? So it says here, if the property is land, consult, and then it indicates who should be consulted. Basically, this question as I read it is basically saying if it's not land specifically, say intellectual property, who do you consult in that context? Because it's not written into the bill. So I guess when you go back to do that process, if you are including any other definition that's not land, as we've discussed here, you also need to spell out who is consulted in those cases.
Thank you very much. Then next, it will be the clause 5.5b, where local authorities are issued with timeframes. No timeframe is stipulated for the state departments to respond to requests for comments. The outlining of a timeframe within which the aforementioned activity is to occur will assist with the streamlining of the expropriation process. And the proposal is that a timeframe of 20 days is included with regard to state departments.
Perhaps the proposal should be explicit as well in terms of defining what we mean by 20 days. Remember, working and all those. As much as I'm saying, I agree, but I think it should be qualified further and then be explicit as well in terms
of working days.
Yeah, so that it can be abused.
Thank you very much. Member, so don't have another meeting in my meeting. Member de Villiers?
We don't have another meeting. Chairperson, I think that is very important. The time frame is very, very important. That we add. We might be specific in what we want in the time frame, but we're speaking to the fact that people are waiting for something back. And there's one worst thing that I ever went through in my life, and that is the letters in the post where somebody they're working on it, but there is no actually an answer to it. So I think a time frame is very, very important for us to work on.
Okay, thank you very much and welcome, Samasa, Advocate Master.
He didn't see.
Mm.
He didn't see.
And Mr. Ndu?
I was saying yes. I think Honorable De Villiers, the issue that is raised in time frame versus expectation, because if you have time frame and the expectations that are actually anticipated elsewhere are not actually met, so why do you actually have time frames? So I'm saying we're noting that, and we'll see how best to actually find expression in terms of expectation versus the time frame.
Yeah. Okay. Advocate Master, you are welcome, sir. Welcome. And okay, I wonder if we are busy with the Annex C of the comments of 2023. Outside there, the first page, does it say comments on the expropriation bill 2023 submitted by the Western Cape government? The
Yes.
top, the cover.
Is he just going to do?
Action. Thank you. And we are on page 14. Okay, so the clause 5.6a, given the level of gender-based violence in South Africa, consideration should be given to require in operational protocols on the implementation of the Act that all inspections are undertaken with at least one male and one female official present, with the property owner having the discretion to refuse entry to either of these officials, but not both. The proposal, possible gender issues associated with the implementation of the Act should be identified and taken into consideration. It is proposed that operational protocols on the implementation of the Act are developed to address this. Mr. Ndu?
Chair, I think I'll sound like a broken record. Remember, it's again the issue of regulation here when we're implementing the bill itself, to say that, yes, we must be sensitive and alive to what is happening in our country, and we must actually speak to the issue of gender, and they're making proposals. For me, I think, this will actually find expression in the regulation, and it's very clear to say that perhaps, we need to actually address this issue to avoid some of the unintended consequences. So I note it, and I agree, unless if they're saying it must be in the Principal Act. If it's in the Principal Act, I've got an issue, but in the subsidiary one, which is the regulation, I agree with it.
Thank you very much. Mr. Jas? Does the Western Cape government have the issue if it's in the regulation or that had to be mentioned in the Principal Act? What's your comment, sir?
Chair, again, this is very much a policy query. I'd only note that it does say, the recommendation does say to put it in operational protocols on the implementation of the Act. I presume that would include, subsidiary to the principal and not suggesting that it be in the principal. But the department would be better positioned to advise.
Osman, do you want to comment?
I'm actually not even sure if it's coming from our department, this comment, but I don't have any comment here.
Chairperson, I think they're very explicit here. They're saying operational protocol, and that deals with the implementation. And from where I'm seated, it's finding expression on the regulation, because regulation give guidance in terms of how to implement the Act. So I thought they're sponsoring it to say that when you negotiate, we flag it as well, to say, when you're going to develop regulation, it must find expression. And like I'm saying, I'm agreeing with it on the basis that it's going to actually find expression on the subsidiary Act.
Okay, thank you. Members? Covered.
Yeah, I'm actually covered, Chair, because I was thinking now that male or female, both. And then the landowner can decide which one. The refusal, not both, one, but not both. Now, if the landowner is a male and refuse the male, is there a possibility of GBV? But I'm fine, Chair. The operational protocols basically should clear that particular issue. Thank you.
I mean, this is just more a is it duty of care, basically? It's just basically saying whoever. I mean, I think you cover it. It's bringing in the principle of being considerate. If you are going to enter someone's property and they're not comfortable with, say, a male in the context of GBV, as a authority that's probably sending people there, you must be mindful of those kinds of realities. I'm sure, I mean, even in schools and everywhere, who searches you and all those kinds of things are taken into account. But I do agree that it's probably an operational issue that one has to just be mindful of. Yeah.
I'm just saying, Chair, that I now have the opportunity to choose whether I will allow the male or female. Right? That's basically what the proposal is saying. Now, if I'm a male, I can decide whether I will allow the male or not and give entry to the female. But yeah,
Okay, Mr. Do or Uspam, you want to? I think on the bill is unless the information has already been obtained, the expropriating authority must deliver a notice to the following persons to provide the names and addresses of all holders of rights in property known to them, as well as particulars of those rights by written reply within 20 days of delivery of the notice. One being the owner, a person apparently in charge of the property, or the holder of a right known to the expropriating authority and the mortgagee. And if the property is land, consult the department, blah, 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 and goes on and on like that. But the question is, maybe from myself, is if this is for the operational issues to enter, why do you have a specific clause talking to it if you can expropriate using the regulation itself to give the how to expropriate? Why was it specific that it has to be mentioned in this? I don't know if I have to ask the government per se. Why I'm asking wrong, because you come from infrastructure and then it doesn't come from the people that I should be asking. It will be those sponsored to this comment to that why are they mentioning it? And because it's okay. I just answered myself as I was asking the question. So let's continue. Okay, clause 5.7. The clause provides that should the property be damaged as a result of a performance of an act contemplated in clause 5.2, an affected person may deliver a written demand to the expropriating authority, and the expropriating authority must repair the damage to a reasonable standard or compensate for that damage without undue delay. It is submitted that the standard to which it must be repaired should not be a reasonable standard, but rather it should be repaired to the condition that the property was in before the damage was sustained. The standard here is a delictual one because the conduct is delictually based, and therefore the standard of repair or value of compensation for the damage must be delictually assessed. And the proposal is that clause 5 of 7 is reconsidered. Mr. Ndu.
I think reconsideration of this clause on the basis of that flagging is noted, and I think they're raising, something to me. It's making a bit of sense in terms of us reconsidering that clause and see how best we can. But reconsideration in terms of actually quantifying what reasonable standard mean, because if you check here, it's a question of semantics. Perhaps they want us to be explicit in terms of how we're going to actually deal with that matter. So, because to reconsider, one would actually expect as well to say, this is my take on the matter, and this is how we should actually reconsider it. We might reconsider and come back the way we have actually flagged it that bit, but it's noted.
Thank you. I think it's more of if you took my cappuccino, return my cappuccino, don't bring latte. Okay.
That's why I'm saying, you could see that there's an element of semantics in the process, because we say standard, I'll be saying, I'm bringing it, it's a standard, this is a pen. I've taken the pen, I'm not saying pen specifically, I'm bringing back whatever taken from you. So I hear we'll consider that.
Okay. Thank you very much. Mr. Mazo, you are with us. Thank you very much. Clause 5.8. The definition for organ of state is the institution of legal proceedings against certain organs of the State Act 2002 contains a close list of what constitutes an organ of state. It is therefore conceivable that the expropriation authority may not be an organ of state as provided for in Il Pacosa. In providing in clause 5.8 that any legal proceedings must comply with that act, the bill non-textually amends Il Pacosa because it extends the application of that act by broadening the definition of organ of state in that act in the bill. Furthermore, if the intention is that Il Pacosa applies insofar as the expropriating authority is an organ of state as defined in that act, then the reference to Il Pacosa in clause 5.8 is not necessary. If the intention is for the provisions of Il Pacosa to apply to an expropriating authority, then it is proposed that it is provided that the expropriating authority is deemed to be an organ of state in terms of Il Pacosa. And the proposal is that clause 5.8 is considered and redrafted. Mr. Ndu.
Chair, again, it's the very same yes, is noted. We'll reconsider that and try to actually see as to whether we can actually align with the proposal that's been put here. Remember, I said it's very difficult for me to actually make a definite what you call commitment. We consider the proposed issues and see as to whether what was the rationale behind when we actually propose those definition, and also redrafting the definition of the state, the organ of the state. We'll reconsider that and offer a proper answer on the basis of that.
5 minutes to a body break. Let's take clause 6. Clause 6 on page 15, members. So it's my watch, it says it's 5 to 11. So we'll break 11 o'clock. Okay. Clause 6, this clause lacks an obligation on the part of the expropriating authority to consider the municipality's comments. And it offers no direction on what should follow if the municipality's response that the intended expropriation or proposed land use will have a negative impact on municipal planning and should not be pursued further. Suggestion, clause 6 should be reconsidered. An obligation on an expropriating authority to consider the comments received from the affected municipality should be added. Mr. Ndu.
Chair, you see the presentation that I've made. I think I've mentioned the question of considering, municipalities and also the development that are going to actually happen in a particular place. So when we said relevant stakeholders and all affected people should be considered, and also their input should be considered, I think, municipalities were actually included as well in the process as to whether, they are going to be particular development in a particular area. So I'm failing to actually understand exactly where is this issue coming from saying the municipalities should be considered and so on and so on, because in the process, whatever is going to actually happen, they are part of it as well. And therefore, the input that they're going to make, they're going to be considered. So maybe clarity should actually be sought in terms of what is it that they're referring to, so that I could actually have a clear picture of what are they referring to in this regard.
Thank you. Ms. Pamela?
Again, Chair, I don't think this is our comment, but the way I've just read the bill now is clause 6 specifically references the municipal manager as having responsibilities rather than the municipal council. I'm wondering whether this comment is not basically saying, because it's not basically saying it should rather be the council rather than the municipal manager, because clause 6.4 says if the expropriating authority is the municipal council, the first time it's mentioning council in that clause of the municipality, therefore where the land is situated, therefore the request contemplated in subsection 1 is not required. But whereas clause 6 to 3 is really referring to the municipal manager and only I don't know if you want to read it and check, but I think that's what it's trying to say. I hope I'm right.
Okay.
Chairperson, I think she's correct. Remember, we are referring to the accounting office of the municipality here. Accounting officer is the municipal manager, and the executive officer, that would be the mayor in this context. So we deliberate and indicate to say that all the administrative related issues should be dealt with the accounting officer. But like I'm saying, we can find a way of how best to do it. One to actually talk about, because the decisions that are actually agreed on in the council, they are carried by the municipal manager, the accounting officer. So that's where we're coming from and indicate to say that the municipal manager. But
when you look at the 6.1, it says when considering whether to expropriate land, an expropriating authority must, if not already established, make a written request to the municipal manager of the municipality where the land is situated to explain how the contemplated expropriation would affect municipal planning. So municipal planning, I think it's the council, not the municipal manager that has to respond to that.
Remember, the municipal manager, plays a critical role in terms of items that are supposed to be debated in the council. You save whatever to, through the speaker's office, and then they're taken to what you call the accounting officer to find expressing in the agenda. So like I'm saying, I think, it's a question of how we can actually tweak it. But the intention there was to see that the accounting officer, who's the municipal manager, must take a lead in the process. But I hear when you talk in terms of the process flow, say that perhaps it might be misread. So let's try to make it explicit. We can panel beat it a bit and make it explicit.
Yeah, I think it will need panel beating, because if I'm a municipal manager, I've got authority through the legislation that I can tell you when you go to the council and now show them that I'm responsible for it, because it doesn't say to municipality through consultation with the council, it say municipal manager must. So if we can.
We can panel beat it and be explicit, that's fine.
Thank you very much. In members, it is 11 a.m. The body break is member Select, you'll continue alone because you already took your body break. And the others that were in here, they can continue with their body break. We can come back. What time? 1:15?
What time is it now? Oh,
it's in, just 15 minutes or 10 minutes. 10 minutes or 15 minutes, it means 10. Okay, 10 minutes past 11. We are adjourned until 10 past 10. Thank you very much. I think there's coffee or tea in the members' lounge that we can try to tackle it. Thank you, members.
Shame, I feel for you. Just
I'm supposed to say no.
I know it's somewhere there. I'm sorry,
What to both? Somebody was.
continue with the meeting. Members, let's continue on the comments on the Expropriation Bill 2023 submitted by the Western Cape Government, Annexure C on page 15. The clause 6(1). In terms of liaising with the municipality in terms of the effect that the expropriation might have on municipal planning, the same principle holds true for provincial planning. It is therefore suggested that this provision is extended to include the responsible provincial department as well. The proposal is that clause 6(1) is amended to include provincial planning and the provincial department responsible for provincial planning. Ms. Ndu, in agreement? It's noted. And 7.2, I don't see anyone who want to comment on that from the members, and Mr. Yes. Clause 7.2 fails to make provision for modern era methods and technology that may make the processes concerned easier, cheaper, and more user-friendly. For example, the bill in clause 7.2G, Roman figure 3, refers to the use of faxes, really. Faxing of documents is an outdated method of correspondence and rarely used anymore. Hi, Mr. Ndu. Are they still manufacturing faxes? The proposal is that clause 7.2 is amended as follows. The word physical be inserted between the words the and address. In paragraph D of the subclause B, the following phrase is inserted at the end of the paragraph D. Open code and the website where the said documents may be accessed, close quote. C, the first line of paragraph J is amended to read open code a directive to the owner or owners, mortgagee or mortgagees, or the holder or holders of a right, and it continues, close quote. And D, paragraph J is amended by inserting after the phrase open quote the names and addresses, close quote, a comma followed by the phrase including email addresses. Noted. Thank you very much, Mr. Ndu. Clause 7.2H, the 30-day period provided in this clause for the recipient of the directive to respond by delivering the written list of the names and addresses of holders of rights and particulars of those rights is too short, especially for recipients who need assistance with the response. The expropriating authority should be required to offer assistance to the recipient. The clause should be amended to oblige the expropriating authority to assist the recipient when necessary to respond to the notice, and the 30-day period to respond to the directive should be suspended where the recipient of the directive requests this assistance.
The timelines where assistance is needed, then they are trying to indicate to say that the period that has been flagged of 30 days is too short. So therefore there should be an extension. I think, let's flag it as a proposal that will actually come to say that can't we actually consider this other leg as well. From where I'm seated, I think it's reasonable because it might actually need a lot of time to assist them, and then 30 days might lapse before you finish the process. So I agree with that, but depending on whatever is going to actually happen at a later stage.
Okay. Thank you very much. Okay, no comment from anyone. Let's continue to clause 7.6A and B. In the scheme of the bill, the point at which the decision to expropriate or not to expropriate is taken by the expropriating authority occurs in this clause. In the case where the minister acts as the expropriating authority, it is particularly important that guidance is provided on what needs to be taken into account in order for the minister to arrive at a decision. No guidance is provided in the clause as to what must be taken into consideration to arrive at a decision. In the absence of clear, discernible guidelines in the bill, the provision may lead to arbitrary decision-making. The court in the Dawood case found that it is an important principle of the rule of law that the rules be stated in a clear and accessible manner. Two of the formal requirements for law to be law of general application is that the law must provide for discernible standards and be precise. The absence of clear standards renders clause 7(6)(a) and B vague and unclear. In the absence of clear standards and guidance as to what to consider arriving at the decision, the absence of such rules may lead to prejudice and is undoubtedly inconsistent with the rule of law and the formal requirements of what comprises law of general application. And the proposal is that clause 7(6)(a) and B is reconsidered and redrafted. Mr. Ndu.
Chairperson, I think I'll raise the issue that I've also raised again, because we are talking about the absence of guidance, and then how do we then actually provide guidance? And we're saying yes, where there are vague statements in the bill itself. When we deal with how the bill should be implemented, that's where we need to be very specific and explicit and indicate exactly how this thing should actually be done. So for me, I note what you call the issue raised, but also I'll go further to say that this is a principal act and regulations should actually cover the issues that we're referring to say there should be a standardized way and the standards in terms of how the issues that are flagged are going to be finding expression.
Something, Mr. Ndu. If a person wants the guidance and then comes to this clause that is not in the meeting and doesn't have the information that the members they do have, that the regulation is there, and pick up the bill to have a guidance, at its finality, will it be able to guide this person to have the right interpretation when coming to this clause as it stands now?
Though I'm failing to understand your question quite well, but I think, the principal act, that's a general standard of actually drafting. The principal act will be drafted in one way or the other at a high level. And in the process, you'll find that the regulation go to the nuts and bolt and indicate exactly areas like this that are actually flagged. We put them aside and say that this area, they need clarity on them, and the regulations should be very, that's why you'll find regulation might have 150 pages, because they try to address all the issues that are quite vague and they're put at the high level in the principal act. So to say we must address the act, like you'll find your act in terms of the driving standard does not actually comply and does not meet that, because it will be voluminous. It will have lots of details in their way. So as much as I'm agreeing, I'm saying some of the things here, particularly where they are referring to say that there should be clarity. Clarity can be always offered in the regulations themselves and also the implementation manual, which is also supposed to be developed as we go along. But unfortunately, that's a standard way of drafting. A lot of things are just actually flagged in that fashion. Chairperson, I think the other thing that is actually necessitating it, remember this is a contentious bill. In other bills, you'll find that, yes, there will be a lot of statements like this, and therefore, when you say, regulations are going to, that's why we're suggesting to say that also in terms of regulations, we should not just actually sit in Pretoria by ourselves and develop them. We should actually have consultation of some sort. We can consult perhaps at a high level without actually going specifically to the areas that we've targeted, so that, whatever we got, should find a clear expression in the regulations themselves. So these are some of the things when we're saying we're noting. We'll classify them and say that we need further engagement, provided the bill goes through.
Can I just no? I'm a bit worried. This thing is really well well worked, this document, from our side, and with our suggestions coming into this thing. But what bothers me a bit is wherever we ask this proposed clause is to be reconsidered and redrafted, we get the same answer. And we spend a lot of time on it by not moving to what we actually want. What I'm trying to say is that those things that we considered to give and where we want it to be changed and what we want to be changed, what the wording should be, I think that is the ones for me that we are making progress on today. Yeah. The others is just the same answer, the same answer, the same answer, because we're not making any suggestions. We're just not happy with the wording. Thanks.
So remember, the process is today. These are the comments that comes from the Western Cape government. So we are looking at that. Remember, we are the legislators ourselves. So we are listening to the comment from national government to say from this annexure, from these comments made from the Western Cape government about the bill itself. After we are still have to go on this document when we're doing public hearing, the comments, the submissions that were made, the national government, Ms. Ndu, will also respond to that. The idea is when we are done, tomorrow ourselves, now we will be formulating our own negotiating mandate where we want to see the changes. So importantly, so is as we get the responses, you should note those clauses in the bill where you want to see the changes, whether being the interpretation of the property, what does it mean, and all that. And then tomorrow, as we do the negotiating mandate, is the one that we will be sending to the NCOP to represent the Western Cape Western Cape Provincial Parliament to say what is our contribution to that bill. Okay. Thank you very much. We are now on clause 7.6. Clause 7.6A provides that the expropriation authority may decide to expropriate the property after, among other things, the amount of compensation has been agreed to. It is logical that if agreement is reached, there would be no need for further action. A decision to expropriate or not would not be necessary because the conclusion of the matter is that it will amount to a sale. The cost for the registration of the property into the name of the expropriating authority in the deeds office at that point would be that of a sale and not expropriation, because the agreement is reached before the notice of expropriation in clause 8 is issued. And then the proposal is that clause 7.6A and B is reconsidered and redrafted. Noted.
Noted. I'm saying noted because you see, we'll be appreciating a situation where perhaps there's a rephrasing in terms of how to capture the proposal. But it's noted and we agree.
Okay. Clause 8. Okay.
I'm just wondering if it's not proposing that you completely remove that then, because that point is moot when an agreement has been reached.
Removed and then it will be captured into loss. Completely removed.
Completely removed, because if I read it correctly, you can correct me, Sendo. It says once the two parties reach an agreement, right? Then you no longer, there's no need for expropriating, so it doesn't follow. So it shouldn't even be written.
Chair, why I'm worried, I'm saying noted, because once you move one clause, you might actually find that you're tampering with the whole bill. So we must actually be very careful when saying remove. That's why also they didn't actually make a suggestion. They are saying clause what, reconsider and redraft. So because they didn't just want to say take it out, because when you take it out and then it has implication on other things that on other clauses as well that have been built on the bill itself. So you might be actually creating substantive changes on the bill, which therefore means that go back to square one because these are substantive changes. But I'm saying we noted that we'll see whether we're not going to tamper with the essence of the bill if we remove it completely. Hence, in terms of their proposal, they're saying, reconsider and redraft. Reconsider. See?
Responding because he was saying he would appreciate if we had said what needs to happen. So that's what I was.
Help us as the members. That means that that clause, even though it sort of captures that the sale has happened, if we do the negotiating mandate, it will have to be written in another form, not to be totally removed. We can suggest something on that, or what do you think has to happen? Because it's not needed. Let's say this clause, in fact, is not needed, but it will be hard work because we're going to do everything.
I was trying to, basically to repeat myself, we would have to redraft it. So he's saying we mustn't say it must be removed, but I think you can correct me that the proposal actually should be written in a way that you don't need this clause if there's not going to be expropriation, and therefore should be removed. Of course, someone must go back then to make sure that it doesn't contradict whatever that had been said in the previous clauses before this one.
So I'm asking the legal people to say that us as the members, if we go to that clause now, negotiating mandate tomorrow, and we don't see that it's necessary because it will means that you have to go back. If you have to advise us about that, what do we do? Is to write it in a way. How do we do it? Because it's not because that means that we speak now, it will be remove that clause.
Chairperson, I think if you check, they were very careful in terms of the proposal that we put there. They are saying reconsider it and redraft it. So when you're reconsidering, like for example, you're saying what they've flatted here. As part of your negotiating mandate, clause 6.6 should be reconsidered and redrafted because we saw these gaps and so on and so on. So when we provide answers, we're providing answers after we've checked the bill in totality and say, perhaps you're reading it in isolation with clause 7, which therefore nullifies what has been captured there. But according to drafting style, that has to actually appear, for the consistency and so on and so on. But I'm saying to reconsider and redraft, it might amount to us dropping it as out completely if it doesn't actually tamper with the bill itself. If it tampers, we'll have to actually find a way of how best we can actually leave it there, but rewording it in a different way.
Understand, but usually from Western Cape, if we reconsider, we also have to say what is the option. So that is why I was asking the question for the members, for us to find out the options. What options do we have when coming to it, where we have, when we do the negotiating mandate, we also give the contribution to say what is it that can be done, and considering what you say that it might maybe have an affect some clause behind that, it will be a lot of work that has to go back. But what are the options that we have from the members as we do the negotiating mandate? And we can't say, if we give the negotiating mandate, we can't say redraft, reconsider. We have to also contribute to say redraft by saying 1, 2, 3, 4. So that's why I'm trying to find out that. Yeah, Member Maran.
So, Chair, make me understand. If I arrived at the farm and tell the owner of the land that we want to expropriate this piece of land, and the owner said you can expropriate but compensate me, is it then expropriation with compensation? I want to understand, why do we need to change a specific clause? I hear what he's saying, that if they agree in terms of what the should be paid for that piece of land, it can't be then expropriation. It's a sale. I can also argue what is expropriation with compensation.
Then it goes back to the question of definition. How do we actually define expropriation? Remember, it will actually include some other angles that perhaps we're talking about here. But if it doesn't actually fall within the definition provided for expropriation, that will actually amount to something else. Because that's why there's a need to actually define concept in the bill so that you can actually contextualize them. So we'll go back and check how the bill defines expropriation. That's why I'm saying it's not as simple as we might think to say take it out or not, because we must go back, check how is it defined. When we're taking it out, is it not actually having implication in terms of tampering with the entire bill in totality? So it's a very bigger issue that we need to actually apply our minds and check how it has been expressed and how is it covered in the bill itself.
Member, do you understand you looked at the clause itself, that why the Western Cape government saying be redrafted and considered. Anyway, let's continue. We will look at that tomorrow to see can we go about, of course, with our advice and advocate must dock with us. Okay, so we are on clause 8. Clause 8 is the clause fails to make provision for modern era methods and technologies. A repeat of that modern era technologies that may make the processes concerned easier, cheaper, and more user-friendly. The proposal that in subclause 3C, after the word address, the phrase or digital repository is inserted. Agreed to? It's noted. Clause 8.3e, the date of expropriation would be the same as the date on which the expropriation notice is served. It is proposed that the bill makes provision for a minimum numbers of days, 30 working days, between the date of expropriation and the date of service of the expropriation notice. We already dealt with that. Clause 8.3g provides that the notice of expropriation must contain, among other things, except in the case of an urgent expropriation contemplated in section 20, the amount of compensation agreed upon or approved or decided by a court under section 19. Clause 8, subsection 3G alludes to the fact that compensation may have been agreed upon between the parties. However, expropriation can only follow if no agreement on the amount of compensation payable is reached. If agreement is reached, such a transaction would result in a sale and not an expropriation. We're talking about, yeah. Okay. Clause 9, subsection 2A, the reality of farming is that it is seasonal and that there is a difference between the date at which capital and operational inputs must be made into the land and the farming operation and when benefits will accrue. For instance, the income of the harvest from palm fruit is generally only generated during late summer or autumn, whilst capital and operational inputs must be made during the winter, spring, and early summer of the preceding year. Hence, if the state of the position is set for the early summer, it is expected of the owner to carry all the costs without any expectation of receiving income from the harvest. This is not poor planning. It is the realities of farming. Any agreement between the expropriated owner and the expropriating authority as to the date of possession must therefore consider the realities of farming. And the proposal is, it is crucial that a provision is included in the bill to the effect that the realities of farming should be considered when the dates of transfer of positions are concluded. Okay, noted. Member De Villiers, the response is noted. Clause 9, subsection 3C. The risk is that the expropriated holder or owner may inflate maintenance costs or create phantom costs to benefit unduly from the expropriating authority. It is submitted that maintenance costs incurred after expropriation up to the date of the transfer of possession must be verified. And proposal is the expropriated holder or owner must provide proof of ongoing maintenance costs. the expropriating authority must verify the costs. It is proposed that clause 9 of section 3C is qualified by placing a restriction on the period for which maintenance costs are payable up to the date of transfer of possession.
Agrees in terms of how to actually do that should be covered in the regulations. I agree with it, and it's making sense. But I'm saying to find expression in the Principal Act, for me, it's a bit of a challenge, but it's making sense.
Okay.
Noted.
Thank you, Ms. Sandy. Clause 9, subsection 5. It is foreseeable that if a property owner is notified that his or her property is to be expropriated, that such a person will take measures to relocate to or acquire alternative property. To hold the property owner liable for the costs associated with the expropriated property up until the date of the transfer of possession may result in the expropriated owner incurring additional costs. It is proposed that measures to minimize the cost of the owner from whom property is expropriated should be explored, such as rates, holidays, etc. Noted. Members? Okay, sorry. Noted. Clause 10. From a reading of the clause, and in particular clause 10, subsection 7, it appears that the power in clause 10, subsection 7 could only be triggered after a verification process has unfolded and after the expropriating authority accepts the claim and the conditions in clause 7, subsection 6 have been met. If this interpretation is correct, then it is submitted that clause 10, subsection 7 must make this explicit. Okay. The proposal is that clause 10, subsection 7 is redrafted to provide expressly that the power in clause 10, subsection 6 may only be exercised after the verification process in subclause 3 has been completed and after the expropriating authority accepts the claim and the conditions in clause 7, subsection 6 have been met. Noted? Members Leku? Okay. Clause 11, how do the words are entitled to compensation align with clause 12, subsection 3? Because the provision deals with the right of a holder of an unregistered right in a property to compensation. If clause 12, subsection 3 is retained in its current form and expropriations are permitted with no compensation in some cases, then the same should apply to holders of unregistered rights. Proposal is that clause 11, subsection 1 is reconsidered and redrafted to state that the clause is subject to clause 12, subsection 3. Okay. Clause 12, which is the general comment. Clause 12 provides for situations wherein it may be just and equitable and in the public interest to pay nil compensation for land earmarked for expropriation. However, the bill does not prescribe that nil compensation will be paid in these circumstances. Instead, the amount of compensation will be determined by the courts. Regardless, there is concern that expropriation without compensation is not an appropriate policy option for redress and a growing economy. Real redress would mean recognizing, entrenching, and expanding the private property rights of those who had their rights violated during the colonial and apartheid eras. Instead, the approach adopted may be viewed as significantly weakening property rights for everyone. As such, it may discourage and deter investment in South Africa. This is not inconceivable, as considerable disinvestment has already taken place as wealthy South Africans offshore their funds and international companies sell their assets. The bill poses a risk to investor confidence, which has the potential to deepen poverty, inequality, and exacerbated social ills in South Africa, in turn placing greater strain on the state's social protection services. That was a general comment. Clause 12, subsection 1 and 2. So clause 12, subsection 1 merely repeats section 25, subsection 3 of the Constitution. As a result, it does not develop the constitutional principles or give any greater guidance and assistance to the officials who will have to apply this provision. Clause 12, subsection 2 ameliorates this situation to some extent by indicating factors that must not be considered when calculating just and equitable compensation unless there are special circumstances in which it would be just and equitable to take the factors into account. This provides negative guidance, but there remains little positive guidance for an official calculating an offer of compensation in a particular case. The absence of guidance raises a constitutional issue. In the Dawood case, the Constitutional Court indicated the importance of providing appropriate guidance for officials exercising discretionary powers. In cases in which appropriate guidance can be given and the absence of guidelines means that affected people are prejudiced, then the absence of such guidance can lead to a provision being struck down. In respect of the clause 12, subsection 1 and 2, considerable guidance could and should be provided to officials. Oh, I'm not going to read all this. Exercising a power to determine appropriate compensation. In case of Detroit versus Minister of Transport, where Constitution Court dealt with the problem of balancing the approach to compensation in Expropriation Act 1975, with that in section 25, subsection 3 of the Constitution. It continues, the court in that case noted that the approach it employed was not ideal and held that it would not have been more expedient, and it goes on. Furthermore, the last paragraph says, furthermore, if state investment and subsidy in their property is considered part of the calculation to determination, the compensation value, private investment in the property should also be considered, especially because private investment is not immediately reflected in the market price, but may only reflect it after a decade or two. And the proposal in that clause 12, subsection 1 and 2 is considered and redrafted. It would perhaps be appropriate to include in clause 12, subsection 1, that the value of private investment in the property, like the value of state investment and subsidy in the property, is also taken into consideration. It is also proposed that the value of private investment is included as a further criteria to be considered during the calculation of the compensation to be paid.
And I think they're making a proposal here in terms of the consideration of the private investment. Perhaps one would actually said, the formula and the calculation of that investment, is something that we need to actually think of and see how best, because it's a proposal from where I'm seated. I was reading that. I'm saying it's one of the valuable proposals that we can actually, put our fingers on and see. But also we must also think, beyond the proposal itself, the implementation part of it. The method and the formula of how to calculate that and make it just and equitable. Okay. But in the proposal from me, it's sensible.
Okay. Members? Okay. Then we continue to the clause 12, subsection 2C, the principle of evaluating the lawfulness of the enhancement prior to valuing the property is supported. Okay. Where am I?
Page 23.
It's page 23. Is the clause 12, subsection 2C. So it supported the principle of evaluating the lawfulness of the enhancement prior to valuing the property. Then we continue on the clause 12, subsection 3. This clause is problematic for the following reasons. 1, the clause sets up a stark divide between cases in which compensation is paid and cases in which compensation is nil. This creates a situation in which the expropriated owner is either entitled to compensation or nothing at all. It is submitted that the clause should rather be of more general application and provide guidance for all cases in which compensation is provided, which substantially deviates from market value. There is a spectrum of possible compensation which can be paid with a nil compensation, possibility merely being one extreme position. It should be made clear that the same factors which justify paying no compensation in some cases may in other cases only justify paying compensation which is lower than market value, but still paying something. 2, a payment of nil compensation is primarily triggered by a public interest, which in turn requires a connection to land reform or reforms to bring about equitable access to resources. The concept of land reform does not render up to an obvious legal meaning, and the bill makes no attempt to elaborate on this concept. In terms of the Constitution itself, land reform would at a minimum involve the provision of equitable access to land resources. That is in terms of the section 25, subsection 4 and 5, secure tenure, section 25, subsection 6, and restitution, section 25, subsection 7. The bill should at least endeavor to expand on the Constitution to provide sufficient guidance to make it clear what is meant by the concept of land reform. Some of the factors listed in clause 12, subsection 3 are vague and provide no clear, discernible guidance to expropriating authorities as to when to compensate when no compensation will be paid. Please see the comments below under clause 12, subsection 3A and D in this regard. As commented above, the requirements for a law to be law of general application as required by section 25, subsection 2 of the Constitution is that it must be clear and precise and accessible. Given the vagueness of the factors listed in clause 12, subsection 3A and D, which is an end of itself renders clause 12, subsection 3 unconstitutional, the words in the introductory sentence to the provision having regard to all relevant circumstances, including but not limited to, empowers expropriating authorities to take into account factors other than those listed in clause 12, subsection 3 of a like value nation. In fact, anything that the expropriating authority may consider to be relevant. It is submitted that the introductory sentence may lead to even more vagueness than that indicated in our comments under clause 12, subsection 3A and D. It is submitted that clause 12, subsection 3 is vague and does not meet the formal requirements of law of general application. Section 25, subsection 2 of the Constitution permits expropriation only in terms of law of general application. In the circumstances, this clause will likely not pass constitutional scrutiny. Proposal that clause 12, subsection 3 is reconsidered and redrafted. Mr. Ndu.
Chairperson, I think in my opening remarks, I said, particularly in relation to clause 12.3, because that's where it talks about nil compensation for expropriation. And I could see that they are dwelling into the provisions covered by 12.3A to D, which I said we getting negotiating mandate from different provinces, and we crafting responses to that effect together with the senior counsellor, the constitutional expert. And because I think what they're raising here is they're raising the constitutionality of that particular clause, particularly A to D. And when we consulted first, we got a legal opinion which was saying, it's in line with the Constitution. I think from where I'm seated, I can't actually give a very explicit answer. I think this merits, to be actually engaged at that level that you're going to engage when presenting your negotiating mandate. I would prefer a situation where perhaps it's covered the way it's actually captured here, and then we provide the responses, and including the other questions that are actually arising around clause 12 from other provinces as well, and we take it from there. But the constitutionality from where I'm seated. It's given guidance by the senior counsellor, and I would say the response is noted as it is, and I would want it to fly to actually find another what you call bite at a later stage. Yes, again, Chair, I would say yes, because it's dwelling around, the clause 12.3, which I'm saying, in the process, we'll actually need the expertise of the senior counsellor in terms of checking as to whether it's aligned with the constitution of the country. And also they are raising another dimension. If you're checking the question of use, we need to actually find expression to say, how do we then actually define it in the bill so that we could actually move from the same page altogether? Because if we use it loosely, it might actually have a different connotation. So I'm saying I'm noting that as well, and we'll see how best the senior counsellor could actually give advice in relation to the constitution of the country. I think it's the question of clarifying, because they're saying it has to be very explicit. It's implicit, as covered, and therefore it must actually read, in conjunction with clause A. So yes, again, I would say it's noted, and therefore we'll see how, the disjuncture that they're referring to could be kept as we negotiating and going forward. Chairperson, I think also the comments that we made, they should be in line with the language that have been also captured in the bill. When we say without compensation, then it's giving a different connotation altogether, because remember the bill talks about nil compensation for expropriation. And there's a body of knowledge that actually differentiate the two. So I'm just saying, when we craft our own negotiating mandate, I think let's try to guide against that, because it will open a different dimension altogether. You might actually find that people saying he's talking about something different. We are presenting a nil compensation for expropriation, and they're saying without compensation. So we got a comprehensive. Yes, I agree, and I understand the issue of abandoned land. It's not actually starting now. It came, when we started with the bill first. We're persuaded otherwise, we changed, and therefore it came again. So I'm saying, I think, I agree with it to say that we can put it again and test it for the fourth time. It was there initially, it went when we got comments, and then came again. Because also at times it's very difficult if you're not the owner of the particular land to say that the land is abandoned, because they'll actually ask you again a question to say that qualifies you to say that it's abandoned. Which facts do you actually have? All those things. So I'm saying from where I'm seated, what they're flagging is quite interesting. It could actually find expression, and then we engage again further. It's true and fro, to and from. It depends on how we get persuaded in one way or the other when we engage. But Yes, I agree with you to say that we need to actually give maybe some definition so that we could actually move from the same page to avoid different interpretations. So I think it's a worthwhile to know. Again, it's you lawmakers who should actually make a final determination. Remember, the proposal in the bill, we're saying these are, the properties like this, particularly in the inner city, are posing, these risks that we've actually determined. And we have read it with the occupational health. But in terms of them to be meriting expropriation, we flag them at that particular category. So there are sensible issues that have been raised here. And again, you have to actually make a final decision as to whether they should actually be put there or be taken out. So they're correct.
Thank you very much. 12.4. This clause non-textually amends Section 23 of the Land Reform of the Labor Tenants Act 1996. This clause introduced confusion and the risk of inconsistent implementation.
Chairperson, you see that there's a Department of Agriculture and Land Reform, and we just actually cited this as one of the things that we should actually consider under clause 12.3. And then we found that it also speaking to that particular act. Maybe there could be some confusion actually reflected, but I would say initially elsewhere when we talk about land reform, I would say anybody who want us to go to the details of land reform in terms of because we're saying this is an acquisition method that could actually assist in terms of land reform. But if you check a lot of questions here, they want us to fall within the ambit of agriculture and land reform, whilst we are providing, the standard procedure for all organs of state. So again, from where I'm seated, I wouldn't want to dwell much on that. We just flag as an example that we can actually use and the circumstances within which nil compensation could be paid using that particular provision of the Labor Tenant Act.
Members? Members Leko?
No, Chair. I've been reading this clause 12. And I mean, Chair, I would want to be part of that NCOP meeting when they deal with this mandate to see how they're going to deal with that one. Because, that's all I can say.
As a chairperson, I will try to see if that can be possible, man, for you to go and represent and be in the NCOP, and then you tell them you just came for the clause. Okay, I'll try that. Member Maran?
I fully agree, Chair, because otherwise, if we these laws of the Land Reform Act of 1996 in a specific clause, otherwise we'll have to go into the Water Act, human settlements, and all those that deals with the issue of expropriation. Otherwise, we will have to look into all those specific acts. And it's correctly stated that this is just a framework. And each department, whether it's land reform, will then have its own piece of regulations. How will they will arrive to expropriation, whether it is without compensation or with compensation. Thanks.
Thank you very much. Let's continue to clause 12.5. Subsection 5. The new subclause 5 would have been more appropriately included as part of the non-exhaustive list of factors that must be taken into account in terms of clause 12, subsection 1. It is recommended that clause 12, subsection 5 is moved further up to form part of the list of factors under clause 12, subsection 1.
Although there's a contradiction a bit, because you see, you're questioning this clause, And then again, providing to see that, to enhance this clause, put this one. So I don't know whether these are the inputs from different
departments.
Oh, okay.
So either the
All right. All right.
it comes from different. So you will hear the agriculture, the infrastructure, the
the
health,
reason why I'm saying
the social development also somewhere on the GBV also. So it's all the departments.
Okay, you get my rationale to say
Yeah.
that if then we're saying above, we're having issues with these clauses, and therefore we propose to say on the very same issues, the very same clauses that we have got issues with, put this one there. So it's a contradiction a bit. So we are saying perhaps, when the report is crafted, we have to be alive to that because the report should be consistent. But I hear you to say that it's comprised of different what you call departments. Okay. So they'll be focusing on their specifics, and therefore we might find that they're not just speaking to each other.
Yeah. Okay. It's noted, Member Maran. Okay. Clause 12, subsection 5, the new subclause 5 would have been more appropriately included as part of the non-exhaustive list of factors that must be taken into account in terms of clause 12, subsection 1. Or is the one that we were dealing with, clause 13, sorry. It is conceivable that a delay in effecting a payment of an expropriation may be to the benefit of a landowner who can claim simple interest for the entire period that payment remains disputed. This may even encourage spurious litigation on the basis that the landowner can claim market value plus interest for the entire time that the payment is delayed. It is proposed that clause 13 should be explicitly worded to make it clear that interest on compensation payable for expropriation is kept by the in duplum rule. The in duplum rule has been recognized, duplum rule has been recognized in our law and means that area interest may not be claimed to the extent that it exceeds the underlying capital sum. The in duplum rule. Hey guys, we are learning it. Okay. The proposal is that clause 13 provides that interest on compensation payable for expropriation is kept by the in duplum rule. Noted. We continue to clause 14, subsection 3, which says no process is provided as to how the expropriating authority may revise its offer and whether the expropriated holder may, after receiving particulars requested in terms of this draft clause, seek to convince the expropriating authority to do so. Provision should be made for a process to be followed by the parties in order for the expropriating authority to revise the offer. The process for the regulation.
Yeah, we're talking about the process again.
Okay. Clause 15, subsection 3, the provisions of this clause may lead to a situation where an owner or holder is without their property and compensation at the same time. It is proposed that where the property is land, the starting point should rather be that only if payment of the compensation is delayed or there is a dispute on the amount of the compensation to be paid, possession may be retained by the owner or holder until a court orders otherwise. Accordingly, all risk and liabilities in the respect of the land should then remain with the owner or holder. Proposal is that clause 15, subsection 3 is reconsidered and redrafted. I understand you. Now noted it, cut and paste, Musma. And at clause 15, subsection 5. Okay, this subsection mistakenly refers to section 20, which should be a reference to draft clause 18. Okay, where's the bill? What happens when the claimant contemplated in this clause is not tax compliant or is not able to produce a tax invoice? Does it mean that their compensation is not paid to the claimant? At least one consequence will be that interest as envisaged in clause 13 will not be applied to the amount of compensation. The provision places on these VAT vendor claimants an obligation to provide proof of the tax compliance and seemingly may punish them for tax non-compliance through withholding the payment of compensation. No obligation is placed on the ordinary claimants to provide proof of tax compliance. The provision in clause 17, subsection 5 effectively distinguishes between claimants that are VAT vendors and all other claimants. The two categories of claimants to which the bill applies are treated differently with no discernible reason as to why this is so, with potential implications for VAT vendors where no interest may be applied should they not comply with this clause 17, subsection 5. Propose that law 17, subsection 5 is reconsidered.
The suggestion, that we have spoken about earlier on, this dumb lamb rule. And I thought perhaps, when they're saying we should reconsider that in consultation with, reading it with the proposal that we actually flagged there. So I'm saying, yes, I agree. But then, the proposal that they've put there should actually also find expression in terms of the proposal that they're actually talking about here. Hence, earlier on, I was very wary to say, once we make one proposal on one clause, it might actually affect 7 or 9 clauses. And therefore, that might actually amount to substantive changing of the bill. So I hear what they're talking about and the proposal that they've actually effected earlier on here around the dumb lamb rule. And therefore, one would have expected it to actually find expression in terms of this proposal that I put in. But I've noted it as well.
Okay. Clause 16, subsection 1, it is not clear what the situation will be if the amount of compensation offered is less than the amount of the mortgage on the property. Clarity is required.
Chairperson, that's why we're saying parties affected before expropriation could actually take place to actually engage each other. So these are things that are going to actually be threshed out before you could actually go to the question of notices. So clarity as well, like I'm saying, it could be like a broken record. Clarity of all these nitty-gritties should actually go to the regulations to actually give a clear effect in terms of what is supposed to actually happen. But about municipality rates, mortgages, and so on, they are covered there, but they're covered at a high level. It doesn't actually present, the clear way forward in terms of how to handle that. We thought when they're flagged in the Principal Act, the regulations will actually take that into consideration and give a clear picture.
Members, covered? Okay. Clause 17, subsection 3B, clarity is required on what the reimbursement payment arrangements will be in respect of any overpayment of pro rata rates by the expropriating authority to the expropriated owner or holder.
Chairperson, again, it's a question of seeking clarity, and we're saying again, it will find that clarity should actually find expression, because it's again a process issue. Only clarity is required on what the reinvestment payment arrangements and expression will actually be reflected there in terms of how you go about doing the issues that are raising there in 7.3B.
Okay. Clause 17.4A have the implications of these provisions being considered on the administrative processes of the deeds office, because it's currently a requirement of every registration of transfer in a deeds office to lodge for examination a rates clearance certificate. There is a requirement in terms of section 118, subsection 1 of the MSA. The provision now makes it possible that where the municipality manager fails to inform the expropriating authority of the outstanding charges on the land that has been expropriated, the registrar of deeds must, despite the provision of any law to the contrary, register the transfer of the land to the expropriating authority. The effect of this clause is to non-textually amend section 118, subsection 1. This may lead to confusion. In many cases, an expropriated owner may be in areas with the rates on the property, and the requirement that a clearance certificate is required is a registration of transfer is often a useful mechanism for the municipality concerned to recover rates that are owing. If clause 17.4A is retained in its current form, this mechanism will not be available to a municipality in the circumstances contemplated in the clause. And the proposal is that clause 17.4a is reconsidered.
Chairperson, I remember we had an earlier discussion around the authority of the council and the municipal manager. And I'm saying it's surfacing again. It's surfacing on the basis of the expression that they're actually taking from the bill itself.
Yeah.
And that's why I'm saying we should be very wary. When we want to change, it might actually affect some other provisions that are covered in the bill. But I hear what they're actually flagging here. But in one way or the other, we might actually find that that municipal manager that we spoke about previously is going to actually stay on the basis of the issues that have been raised at a later stage, so that we can actually have congruence and coherence, in terms of the flow of the bill. But issue is noted, and we can see how best. That's why to reconsider and redraft on the basis that it must actually talk to each other as a bill in totality.
Okay. Clause 19, subsection 1. This clause provides that if the expropriating authority and disputing party do not agree on the amount of compensation, they may attempt to settle the dispute by mediation. It is proposed that mediation is used for all expropriation disputes leading up to the compensation offer, including enhanced rights, enhanced value, and land use. See comments under clause 8, subsection 3. It is proposed that mediation is used for all expropriation-related disputes.
Chair, I think, for me, that's a valuable what you call input, because you're talking about mediation so that you can't actually have dispute, and we can actually use it throughout the process, but provided it doesn't actually have financial implications and the cost involved in a way. Initially, I reflected to say that in this regard, mediation, it's parties that are not going to actually be given any compensation in a way, because if we don't find each other, we go to the court, and the court will actually be needing money as well. So I'm saying the proposal from where I'm seated, it's welcomed.
Thank you. The clause 19, 6, 7, clause 19, subsection 6, 7, and 8. It is not clear whether initiating proceedings in terms of the clause 19, subsection 6, for example, approaching a court on any matter relating to the application of this act will suspend the notice or effect of expropriation pending the finalization of the matter in court. From an administrative point of view, it is suggested that any notice of expropriation which is challenged due to non-compliance with the act should be suspended until court has reviewed the matter and made a determination, given the potential disruption of livelihoods and result in the least cost to the state. And the proposal is that a challenge in terms of process or compliance with the act should suspend the expropriation pending the cost determination in this regard.
Person, I think the proposal is noted because remember in the bill we said the court should be used as a final arbiter, so you can't actually exercise and proceed while there's a pending matter before the court. So I'm saying I note that, and I agree to say that we must actually find some expression around that particular aspect.
Okay. Thank you. For clause 20, how do the words entitled to compensation in clause 20 subsection 4 align with the clause 12 subsection 3? Mr. Ndu? The proposal is that clause 20 is reconsidered and redrafted.
I'm going to read, I'm reading down and checking exactly what they've actually said around that, because if we consider the entitled only, let's just read this one so that we could have it.
So it says, this provision deals with the right of an owner of or holder of an unregistered right in a property to compensation. If clause 12 subsection 3 is retained in its current form and expropriations are permitted with no compensation in some cases, then the same should apply to owners or holders of unregistered rights in a property in the case of urgent expropriation. It is proposed that clause 20 subsection 4 is expressly redrafted to be subject clause to 12 subsection 3. The process of expropriation mapped out in that clause only provides for the initial offer of the compensation and exempts the expropriating authority from having to comply with clause 5 subsection 1, 6 subsection 1, and 7 subsection 1. The departure for the expropriation process provided for in the bill will only be lawful if it is reasonable and justifiable in the circumstances. This is a requirement of the Section 3, subsection 4A of PAJA. The circumstances of each case of agency must therefore be assessed and considered as to whether a departure may be justified. It is therefore submitted that Clause 20 cannot simply generally exempt the expropriating authority from having to comply with the expropriation process contemplated in the bill. Instances of departure from the process will have to be assessed on a case-by-case basis. And the proposal is that Clause 20 is reconsidered and redrafted.
Chairperson, I think there's an element of agent expropriation that they're talking about, and I like their conclusion there to say that let's consider this on a case-by-case basis, and therefore one would actually say that agent expropriation at times is talking to natural disasters that are not actually determined by anybody. So therefore, that's exceptional circumstances that we need to actually consider. So that's why the process is actually not going to be followed because it's an agent matter. For example, if we seated here and the natural disaster just struck on the other corner and we needed a property, that's where we were flagging the question of agent expropriation to actually speak to that immediate natural disaster that actually took place. But I hear, because they're saying there's a process, there's a standard, and we're talking about agent expropriation. It's like, it's no longer actually talking to the process that we've actually flagged.
Yeah.
So we try to contextualize for the unforeseen circumstances, which perhaps in one way or the other, as lawmakers, we should assist each other to say, what do we then actually deal with a situation like this if we need property to actually house, for example, people. So that's where the clause of agent expropriation is coming from. But I'm saying I note what they're saying. There's a bit of contradiction between the process and agent expropriation.
The agent, okay.
So it's something that we need to actually look into and see.
Okay, members, still, okay. Okay. Clause 20, subsection 6 and 10. Clauses 20, subsection 6 and 10 appear to duplicate each other as well as contradict each other. Please see a comment under clause 5, subsection 7 with regard to the standard of repair or payment of compensation. It is submitted that the standard of repair proposed in the comment under clause 5, subsection 7 is provided for in this clause. And the proposal is that clause 20, subsection 10 is deleted and clause 20, subsection 6 is redrafted to include a standard of repair as proposed under the comment on clause 5, subsection 7.
Chairperson, again, the proposal in terms of duplication, that's why I was saying also, on the previous comment that I've made, we need to actually check that as well, because we might actually find that there's a bit of duplication, but that duplication is made on the basis that, the bill should be coherent. And therefore, once you take the other one out, it might actually temper the whole text of the bill. So I again, I'm noting that, and then we'll see how best we can actually redraft if it's possible, and therefore it won't temper with the essence of the bill.
Okay. Thank you very much. Clause 20, subsection 7, clarity is required on whether compensation will be offered for the extended period of temporary use. If so, provision must be made accordingly.
Chair, in terms of a temporary expropriation, I think we have reflected the timelines there in terms of when compensation be paid, and we also reflected to say that temporary should not actually exceed a period of, I think, 12 months. So it's covered by the bill itself, and the modality, like I've said, the regulations should actually deal with the modality in a way, but the periods are covered by the bill. And when is agent expropriated, expropriation supposed to be implemented.
Okay. Members? Okay. Clause 21, subsection 3B. An endorsement on the title deed of land where the property has been expropriated is only made when the property is registered in the name of the expropriating authority. In terms of clause 21 2B, withdrawal of the expropriation is not permitted where the land has already been registered in the name of the expropriating authority. Clause 21 3B provides that if an expropriation of the property is withdrawn, the registrar of deeds of the registrar or of any other office at which such expropriated rights has registered or recorded must cancel any endorsement made in connection with expropriation in his or her registers. And on the title deed in question, the scenario in clause 21 3B could therefore never unfold practically because of the clause 21.2b. Clause 21.3b is therefore at odds with clause 21.2b. And the proposal is that clause 21.3b is reconsidered and that references to the registrar of deeds and to the title deed in the provisions are deleted.
Chair, again, I think we have provided the time frame of withdrawal. We spoke about, I think, 3 months to say that withdrawal will actually be accepted within the 3-month period. And then if 3-month period lapses, therefore, there's no need for withdrawal because the processes will be actually unfolding. Yes, the proposal that they're putting there to say that we must actually, look into the 21.3b, be reconsidered, and we reference it to the register of deeds and the title deed. I think we'll look into that so that it can't actually be in contradictory with the 3-month provision that we've actually flagged.
Okay. Thank you. Clause 25, subsection 2. And it says clause 27.2 empowers a civil court to impose a civil penalty on a property owner who fails to respond to notices issued by an expropriating authority. It is submitted that the provision must distinguish between cases in which a property owner requires assistance to respond to the notices from the expropriating authority, as opposed to cases where the failure to respond is deliberate. And proposal is that clause 25.2 is reconsidered and redrafted.
Chair, again, you remember we offered the answer before, and then I agree to say that if no assistance is needed and therefore it's going to drag and actually exceed the time frame stipulated. So therefore, we must be considerate to that provision as well. So this one will actually read with the answer that we've actually given before, and they should actually be in sync with each other to avoid contradictions.
Okay. Members? Remember, I don't have your own meeting here. Okay. Clause 26.2b. The making of the regulations often constitutes administrative actions. The regulations on fair administrative procedure 2002 provides in regulation 18.2a that a notice inviting members of the public to submit comments in connection with proposed administrative actions may not be earlier than 30 days from the date of publication. Section 3.4a of PAJA permits a departure from the 30-day period if it is reasonable and justifiable to do so. Nothing in clause 26.2b indicates why it would be reasonable and justifiable to publish draft regulations for 20 days instead of 30 days. There is no clear justification for the 20-day period. And proposal is that the 20-day period is substituted with a 30-day period.
Chairperson, I think this comment we might be actually getting for the third time in terms of actually giving the community enough space to actually make comments, and why do we actually have to take a minimum time frame stipulated in terms of actually publications for comments. So from where I'm seated, 30 days, I would be amenable to that, even 80 days, but provided it's within the time frame that are actually flagged and acceptable in terms of the giving public to actually make their comments. So 20, yes, it's true. It's minimal. 30, we can go for it. And in the previous bill, the 50,000, I think we have given about 21 days, and therefore the comments came as well to say that that was not enough. So the proposal from 20 to 30.
Okay. Yeah. Advocate Minister, you're still with me. Okay. Thank you very much. And we are on clause 27. And it provides as follows: 27.1, a regulation or notice or an authorization document made or issued in terms of this act. A, but which does not comply with any procedural requirement of this act, is nevertheless valid if the non-compliance is not material and does not prejudice any person, and B, may be amended or replaced without following a procedural requirement of this act if I, the purpose is to correct an error, and the correction does not change the rights and duties of any person material. 2, the failure to take any steps in terms of this act as a prerequisite of any decision or action does not invalidate the decision or action. If the failure A is not material, B does not prejudice any person, and C is not procedurally unfair. With regard to clause 27(1)(b), it is submitted that the clause is open to abuse. If it is not necessarily to follow the procedural requirements in amending or replacing a notice, document, or authorization where the non-compliance leading to the cause of the amendment or replacement is not material and does not result in prejudice, then in all cases where issues that are considered to be immaterial and prejudicial, it means that potentially no procedural requirements will have to be complied with. It renders the provision open to abuse. It is also not clear why on a reading of clause 27(1)(b), it will be necessary if the matter is not material and not prejudicial. There would be a need to go back and fix the non-compliance. It is submitted that the cause of the non-compliance must distinguish between errors of fact and errors of law. It is trite that a functionary cannot simply revisit an error of law to correct it. That must be done by a court. Only errors of fact are capable of such correction. It is submitted that the provision cannot intend to enable a correction of an error of law. It is also not clear who would be tasked with assessing whether the non-compliance is material or prejudicial or not. The bill sets its own process, which, although different to PAJA, must still pass muster. To the extent that it does not, PAJA will apply. The provision effectively permits official space not to follow the bill's own rules of procedure. That in itself constitutes procedural unfairness in that the bill's own rules of procedure are not followed. Clause 27(2)(c) is therefore a contradiction in terms. And the proposal is that clause 27 is reconsidered and redrafted.
Noted.
Noted. And then with that last noted, honorable members, we are done with the Annexure C, comments on the Expropriation Bill 2023 submitted by the Western Cape government. Now we are going to take the City of Cape Town submissions. And is this one? Okay, so on the City of Cape Town, the submissions, the comment is this. Section 25(2) of the Constitution of the Republic of South Africa, 1996, states that property may be expropriated only in terms of law of general application, subject to compensation approved by court of law. The bill in its current form, however, provides two specific instances where nil compensation would be deemed equitable. It is the city's view that the bill in its current form will not pass constitutional muster. Although the city supports the objective of land reform as one of the means to bring about redress for the injustices of the past, the city cannot support a bill that is in direct conflict with the provisions of the Constitution. It is suggested that expropriated holder be replaced with expropriated rights holder or expropriated holder of rights to more clearly mirror the positive version of the term as defined in Section 1. Furthermore, the bill should more clearly specify what qualifies as urgent expropriation. Although some suggestions are listed in Chapter 7, it is suggested that this term be specifically defined in Section 1 of the bill. Additionally, please see specific comments for your consideration below. Okay. 1. Chapter 3, Clause 6, subsection 1 to 4. Consultation with municipalities during investigation. When considering whether to expropriate land, an expropriating authority must, if not already established, make a written request to the municipal manager of the municipality where the land is situated to explain how the contemplated expropriation will affect municipal planning. 2, the request contemplated in subsection 1 must include a statement that the expropriating authority is contemplating the acquisition of land, a full description of the land in question, details of the purpose of which the land is required, and other details that the expropriating authority considers necessary. 3, the municipal manager must deliver a written response to the request contemplated in subsection 1 within 20 days of receipt within a reasonable time to be agreed between the expropriating authority and municipal manager. If the expropriating authority is the municipal council of the municipality where the land is situated, the request contemplated in subsection 1 is not required. Comment is implicitly, this clause addresses the requirement to consult a municipality in cases where the municipality is not the expropriating authority. However, it lacks an obligation on the part of the expropriating authority to consider the municipality's comments. It also offers no direction on what should follow if the municipality's response is that the intended expropriation and or proposed land use will have a negative impact on municipal planning and should not be pursued further. Stanley?
Chairperson, I think some of the comments are just actually repeating what we've actually covered before.
Yeah.
But by and large, you know, I would focus much on the comment because if you check the text, you know, in one way or the other, we have actually yes. You see, again, they are talking about the implicity of some of the things that are actually covered in the bill itself. And they zoom specifically into their own terrain, the municipality. And you could see to say that from where they are seated, they're trying to differentiate between the role that the municipal manager plays versus the council itself. And in this context, they are also reflecting the question of consultation to say that, you know, if, you know, the municipality is it's not the expropriating authority, consultation should actually be done. But also whatever they are going to raise, it should be taken into consideration when you're about to expropriate. So, Chair, from where I'm seated, I think there is merit in terms of what they're actually flagging to say that we need to be very explicit, but not in the principal act like we have said before. The regulation should actually give some guidance in terms of how these issues that are pending are going to actually be dealt with. So it's a valuable comment, and it can find expression in the regulations like I've said before.
Okay.
So I think that's how far I can go, Chair.
Okay. Thank you very much. And the Chapter 4, Clause 7, the notice of intention to expropriate, they say the whole section on the bill. And then the comment is that a distinction is made between the expropriation of land and the expropriation of property. However, there is no distinction made in terms of the process of expropriation of privately owned land or property or land owned by the state. Clarity should be provided on whether the process to be followed is the same. Additionally, it should be explicit that the notice of intent to expropriate follows the investigation and consultation with the municipal manager as outlined in the previous clause.
Person, again, they want us to make a distinction between, you know, land and the property. And I think our definition of a property is as contemplated by the Section 25 of the Constitution, and it includes land. So, and I think they are correct as well to say that when you go to the nil compensation provision, we are explicit, we talk about land, as if, you know, land is not actually part of the property. So I think those are the general, what you call, you know, comments that we actually getting in terms of how best we can actually tighten the bill. But property has been defined inclusive of the land in the bill itself. So I note the comment.
Thank you. And we are in Chapter 5, Clause 12, Subsection 3, the determination of compensation. The relevant text is the subsection 3A and E. And it may be just an equitable for nil compensation to be paid where land is expropriated in public interest having regard to all relevant circumstances, including but not limited to A, where the land is not being used and the owner's main purpose is not to develop the land or use it to generate income, but to benefit from appreciation of its market value. when the nature or condition of the property poses a health, safety, or physical risk to persons or other property. And then the comment is that subclause 12.3a is particularly problematic as a developer may legitimately be establishing a pipeline of developments, with some under construction, some in detailed design, some in conceptual planning, and others not yet started. Land banking for this purpose is not without cost to the developer or even to an owner that plans to sell to a developer at an appropriate time, rather than develop the property themselves. There are far better ways to discourage land banking for speculation purposes, such as, for example, increasing the property rates payable for undeveloped land to increase the holding costs for speculators. Subclause E should be limited to cases similar to subclause D, where the cost of addressing the health, safety, or fiscal risk exceeds the market value. In addition, this use case should be the last resort after failure of the owner or holder of rights to rectify the condition of their property. I think that is all.
Yeah, that's it.
Mhm.
Chairperson, perhaps to just throw it back to you members. If there are 5 provisions and the questions is around 2, does that mean 3 are supported? Because I think they are very explicit here. They're talking about A, E, and then they refer D as well in the process and say, whatever you're going to apply to E, apply it to D. So does that mean B and C stands?
Yeah, that means the A, the E, and the D.
And then B and C are supported.
That means from them, they don't have comment. I don't know, supported is a big word. They don't have comment attached to the B and the C, as per the notes that are here.
That's why I want guidance from you, Chair, because when this thing is on record, because they're there, it's 1, 2, it's A, B, C, D, no comment, it's not reflected even here. I know I've used a big word to say supported, but also when you get to that level, those are some of the things that are going to reflect in the process in any way. But anyway, I think what they're raising, Chair, because we spoke about this provision A to D, and then it's also raising the question of constitutionality of some of them, and I think they're trying to actually add meat on that. You can beef that up as well, given the prior engagement that we had around clause 12.3.
Yeah. Okay.
So Chair, in terms of clause 12.3, I don't want to dwell much in terms of that because it has got a lot of what you call limitation, but.
Okay.
I've noted that.
And that is from the city. That was the last comment from the city. And then now, the AfriForum submission. Okay. From the AfriForum, okay, in the meantime, we send you some. Okay, we can continue the point. No, I thought, and what I thought, my apologies, but it seems you were right. I was wrong. Okay. Let's continue with the AfriForum members. And the first, which is number 2 on page 1, the unlimited power of the minister to expropriate any property. And I'm not going to read the introduction to them. It's not important to read the introduction. Must I put it, must I read it for the record? Okay, for the record, the introduction of the AfriForum is that they submit Okay, it says we submit our submissions on the expropriation bill B23-2020, the bill with this document. This document is a revised version of AfriForum's commentary that was dated 9th February 2021, the day upon which the bill served for consideration before National Assembly. We submit that this bill should not be adopted as an act of parliament under the broad consideration that its adoption will have a devastating impact on all South Africans' lives in the context of home ownership, food security, and economic devastation. We'll also demonstrate that various sections of the bill are unconstitutional and could be successfully challenged in the courts if the bill is not revised before its adoption. Okay. So the unlimited power of minister to expropriate any property. 2.1, the bill defines property as the definition contemplated in Section 25 of the Constitution. Notably, Section 25 does not exactly define property, except to know the government's expropriation powers are not limited to the expropriation of land. And it stands to reason that the bill's purpose in defining property as such is to also include movable and intellectual property. 2.2, various constructions in the bill support this interpretation. For example, Section 5(1) of the bill compels government to investigate proposed expropriated property suitably before issuing an expropriation notice. Section 5(2) then proceeds with a proviso that states that if the property is land, government must appoint evaluator. The inclusion of this proviso suppose the interpretation of the bill will give government the power to expropriate any form of property. 3, Section 3(1) gives the Minister of Public Works and Infrastructure, the minister, the power to expropriate property for itself or at the behest of another organ of state if this expropriation is for a public purpose or in public interest. According to the Section 1 of the bill, public interest is defined as the nation's commitment to land reform and to reforms to bring about equitable access to all South Africans' natural resources to redress the results of past racial discriminatory laws of practices. And the public purpose is defined as that it includes any purposes connected with administration of the provisions of any law and organ of state. Section 3.3 of the bill states that property to be expropriated applies to property connected to the provision and management of the accommodation, land, and infrastructure needs of an organ of state in terms of minister's mandate. Okay, and they noted in our previous commentary, that the inclusion of this words create ambiguity in the bill. On the other hand, the definition of public interest includes government's redistributive policies, and public purpose includes administering any law by an organ of the state. However, on the other hand, expropriation is limited to property falling within the minister's mandate. We accept that this implies procurement of land and buildings of the state organs and maintaining these buildings. I can't remember us dealing with this one. Did we talk to it also? As you see me, Mr. Ndu, I'm sorry, as you see me reading those that I know that we dealt with, I will pass through. You will see, I don't look at you. Those that I haven't heard that we dealt with, I'll look at you.
That's fine. I think this has been presented already as well to the select committee. It's fine. I know just to I know
okay.
We have over to response in terms of this one.
Okay,
it's fine.
So you'll do the overall response to it. Okay, that's brilliant. Okay, so the definitions on the 2.8 members, the definitions are broad enough to encompass wholesale expropriation of any property, albeit immovable, movable, or intellectual property. However, the minister is limited to his mandate as provided in Section 3, subsection 3 of the bill. Notably, the bill does not define what the minister's mandate is, nor does it refer to any empowering provisions where the scope of the minister's mandate is explained. For purposes of commentary, we assume that government's power to expropriate is the wide powers explained below. Notably, on 2.9, Section 2, subsection 1 of the bill prohibits any arbitrary expropriation that is not in public interest or is not for public purpose. This limitations has no value as both definitions are broad enough to encompass any any redistributive policy and the administration of any law by any organ of the state. For example, the redistributive policies include the vesting of mineral rights in the state, the administration of the extensive social grant system, the proposed national health insurance scheme, and land reform policies. This bill will give government the power to expropriate any property in pursuance of administration and administering these various laws. To name but a few, at first glance, which is 2.10, it may seem an overstatement. However, government suggested in the past to seize pension funds to fund infrastructure development. And the ANC stated in their 2019 election manifesto that government will investigate and consider using so-called prescribed assets on financial institutions to fund social and economic development. At the least, government has a concerning interest to access large pools of funds held in the private sector to fund its policies, which makes the broad definition of public interest in the bill a cause for concern. For example, consider the urgent expropriation powers that are granted in terms of Section 22 of the bill. If we hypothesize that this bill was enacted in the current national state of disaster due to electricity crisis, this section of the bill would allow government to urgently expropriate any property in case of national state of disaster. Under the broad powers of the to expropriate under the bill, government could unilaterally expropriate any electricity generating equipment, or even under the broad definition of property, the patents for an intellectual property of this equipment. The culmination of the above considerations lead us to the conclusion that broad power to expropriate, not only in the form land distribution policies, but also wholesale distribution policies of government, poses a threat to property rights. It is also submitted that giving the minister such a broad scope of power to expropriate property renders Section 3, subsection 1 of the bill unconstitutional. Arbitrariness have been interpreted before by other courts to mean that there is no rational connection between the purpose of the expropriation and the expropriation. The broad powers granted by bill do not clearly define what circumstance would qualify as public interest or public purpose to a minimal degree of certainty to apply coercive rationality tests as explained above. These are countless administrators of countless acts of parliament by government departments and agencies. Such a low bar of scrutiny we submit will not pass the limitation requirements of Section 36 of the Constitution. Okay, the 2.14, the currently overbroad description of ministers' powers does not allow us to scrutinize the limitation, the relation between the limitation and its purpose, or to assess that any restrictive means to achieve the purpose as set out in Section 36, subsection 1 in the Constitution. An intrusive passage of this point comes from the judgment of case in another versus Minister of Safety and Security, which stated, in determining overbroadness, that is, considers the virtually unlimited range of unconstitutional potential application of the Act to overwhelm whatever permissible proscription might be identified. We submit the bill is subject to the same objection. Potential unconstitutional applications overwhelm the few possibly justifiable instances. With such a broad range of power, citizens are left with a judicial view of an administrative act, namely the decision to expropriate property in terms of promotion of Administrative Justice Act 3 of 2000, which does not offer citizens sufficient protection as argued in the following section. Expropriate now, argue later, still unresolved. Sure, it's so drama in this paper. In its previous form, Section 21 regulated the dispute resolution mechanism that regulates the procedure if expropriated authority the owner cannot see on the amount of compensation. This is now contained in Section 19. Member Sileko, you can continue for us, please. We are on page 4 of the AfriForum 3. I read 3.1. Continue with 3.2.
3.2, the previous version. of the bill set out the right of the expropriated owner to dispute the various steps taken in the expropriation process. Section 21, subsection 8 of the previous version of the bill provided that in any dispute is pending concerning the determination of just and equitable compensation that must be paid in terms of Section 12. The lodging of the dispute does not preclude the operation of Section 9. We are encouraged to see that Section 21, subsection 8 of the previous version of the bill has since been removed in its entirety. Section 19, subsection 8, the equivalent provision in the new bill, now reads that an appeal against the decision of the court on the amount of compensation payable does not prevent the expropriation from proceeding. However, the owner may seek an interdict if there are compelling prospects of success on appeal. Section 9, the provision relating to the transfer of rights is not subject to Section 19, and therefore, despite the removal of Section 21, subsection 8 from the old version of the bill, we submit that the new version 19, subsection 8 is convoluted reformulation of the same principle in the previous version. First, there is no express provision that Section 9's operation is suspended during any dispute resolution process under Section 19. Second, there is no express provision that any litigation that pertains to the decision to expropriate, for example, a judicial review under the Promotion of Administrative Justice Act 3 of 2000, suspends the operation of Section 9. If there is no provision that suspends the operation of Section 8 and 9 in the event of a dispute over the compensation amount, what is the purpose of including a provision that the operation of the expropriation notice during the appeal process can only be suspended through an interdict? Does this simply that the Section 8 notice is suspended before the court hands down a judgment on the compensation amount? If so, we suggest that the bill should make it clear by including a provision in Section 9 that Section 9, subsection 1A is suspended until the court has made a decision under Section 9 of the bill, subject to the provision of Section 19, subsection 8. If this is not the legislature's intention, we submit that Section 19, subsection 8 of the bill is unconstitutional. Akin to Section 164 of the Tax Administration Act 28 of 2011, which provide that a tax obligation remains due to the South African Revenue Service pending any objection or appeal. The bill creates a similar mechanism through which property can still be expropriated effectively despite a pending review of judgment. This aspect of the bill is manifestly unjust. Expropriate now, argue later is a complete consolidation of government power to confiscate property without judicial oversight. We submit that Section 19, subsection 8 of the bill is unconstitutional insofar as it allows for expropriation before the amount of compensation is either agreed upon or determined in a court of law. As it amounts to an unconstitutional form of self-help by the state to take property without judicial oversight. From the outset, it is unconstitutional when considering the wording of Section 25, subsection 2B of the Constitution, and I quote, subject to compensation, the amount of which and the time and the manner of payment of which either been agreed to by those affected or decided or approved by a court, close quote. A cursory regarding of this section logically implies that the determination of compensation, either agreed to or ordered by the court, is the precondition for expropriation. On this basic construction of Section 25, subsection 2B of the Constitution, Section 21, 8 of the bill stands to be declared unconstitutional. Section 19, subsection 8 of the bill is also unconstitutional if one considers the judicial sentiment that reigns in our courts. In the case of the University of Stellenbosch Legal Aid Clinic versus Minister of Justice, the Constitutional Court declared Section 65J, 2A and B, 1 of the Magistrate Court Act 32 of 1944, which allows for the issuing of emoluments attachment orders without judicial oversight, unconstitutional. The majority judgment penned by Cameron J. held in the context of executing judgment in the attachment as follows. It has been established in the jurisprudence of this court that execution of court orders is part of the judicial process. It requires judicial oversight. Though previous cases dealt with debtors' homes, the principle underlying them was that judicial oversight of the execution process against all forms of property is unconstitutionally indispensable. Clearly then, the fundamental principle relating to the proscription of self-help flowing from Section 34 right of access to courts apply with equal force to the execution process. Even though the ratio of the judgment applies to citizen horizontally, Section 8 of the Constitution guarantees that any right in the Bill of Rights is enforceable against the state. And this includes a vertical application of the right of citizens to have a dispute in terms of the expropriation of their property to be decided in a court of law. The Constitutional Court has consistently applied this principle in judgments such as Gondwana versus Tego Development and others. Chief Lisapo versus Northwest Agricultural Bank and other, and Jafta versus Kuman and others, Van Rooyen versus Colt and others. In the context of Criminal Procedure Section 21 of the Criminal Procedure Act 51 of 1977 provides that someone's property may only be seized with judicial oversight in the form of a search warrant issued by either a magistrate or a judge. Of course, Section 22 of the same Act, which only applies in limited circumstances, does not require oversight. Still, that limitation is justified in exceptional circumstances in terms of Section 36 of the Constitution and is the exception rather than the rule. Preservation of property in terms of Section 163 of the Tax Administration Act 28 of 2011 provides for SARS to attach property if it suspects that it will be disposed of to frustrate the collection of taxes, but only once authorized to do so by order of the High Court upon finalization of an ex parte application. Prohibiting the state and the government from summarily expropriating its citizen property without lawful cause and the oversight of an independent judicial officer strike the core of a republic governed by the rule of law. Crichton J. held in the judgment in the Phobos Apollo Aviation, CC versus Minister of Safety and Security, that the protection of property in the Constitution is aimed at protecting private property rights against governmental action. Any act which runs incongruent with this basic purpose of the Section 25 of the Constitution cannot pass constitutional muster. It axiomatically runs against the purpose of this right. This is law. In Premier Eastern Cape versus Tekeshe, Madlanga J held the following in respect of Section 25 of the Constitution. In my view, these sections call for more careful consideration of all the relevant factors before the relevant administrative functionary takes a decision adversely affecting the property rights of an individual, as a failure to do so may result not only in violating of the odi alteram partem rule, but also in the violation of the rights entrenched in Section 25. On a preponderance of the relevant available authority and judicial sentiments related to the rights entrenched in Section 25 of the Constitution, it overwhelmingly supports the submission that the self-help provision in Section 21, subsection 8 of the bill is not constitutionally sound.
Thank you very much,
Yo.
Member Selekum. Member Maran will take over from 4.
You should have given him that one.
Member Maran, take.
Thanks, Chair. The issue of expropriation without compensation. It is unfortunate that the bill persists with its notion of null compensation or expropriation without compensation. Section 12 of the bill provides that compensation for expropriation must be just and equitable, balancing public interest and the expropriated owner's interest. Section 12(3) makes provisions for null compensation to be paid, subject to certain considerations. We have 2 separate issues in respect of Section 12 of the bill. First, the existence of the possibility of null compensation, and second, the limitation of what may be considered when making an offer for compensation. Is there a valid reason for law that states government can expropriate citizens' property without compensation? The answer remains no. There is a myriad of reasons why there is no place for such a law in society governed under the rule of law, human rights and dignity, equality and freedom. Domestically, the wording of Section 25 of the Constitution does not allow for expropriation without compensation. It reads that property may be expropriated only in terms of law of general application, for a public purpose or in the public interest, and subject to compensation, own emphasis, which is agreed upon or decided by a court. It does not require extensive interpretive logic to conclude that the use of the word and in Section 25 requires the expropriation of property to comply with the qualifications for public purpose or interest and compensate payable. No construction of Section 25 can ignore the meaning of the word and, which makes payment of compensation and peremptory requirements for expropriation to be constitutionally permissible. The F&B judgment confirmed that all 3 conditions present in Section 25(2) must be complied with collective together with the conditions set out in Section 25(1), which prohibits government from acting arbitrarily. Internationally, the preponderance of authority dictates that no compensation is not a norm applied in the Society of Nations. What follows is a list of constitutional clauses considered. The Fifth Amendment to the United States of America Constitution states, "Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation." Article 4(3) of the Basic Law for Federal Republic of Germany states, "Expropriations are only permissible for the public good. It may only be ordered by or pursuant to a law that determines the nature and extent of compensation." Section 8(1)(b) of the Constitution of Botswana states, "No property of any description shall be compulsorily taken possession of, except where the following conditions are satisfied." B, provision is made by a law applicable that taking of possession of or acquisition for the prompt payment of adequate compensation. Article 16 of the Namibian Constitution states, "The state or competent body or organ authorized by law may expropriate property in the public interest, subject to the payment of just compensation, in accordance with the requirement when processes determined by an act of parliament." Section 12(3) of the bill is unconstitutional under Section 36 of the Constitution. The first metric that Section 12(3) must pass is the limitation of the right. In this case, the right to compensation for expropriated property under Section 25 must be reasonable, justable, in an open and democratic society. By logical implication, this requires that similar democratic societies have similar limitations and similar rights. Based on cursory consideration of the democratic society cited above, the state's right to expropriation is categorically tied to the duty to pay compensation. No open and democratic society allows expropriation without compensation. By this metric alone, Section 12.3 of the bill is unconstitutional and should be removed. We have noted the argument that suggests that the bill does not allow for expropriation without compensation because it states that sometimes the compensation is null. This implies that the state does pay compensation, but the amount is simply null. We state that this cannot possibly stand as a rational justification for including Section 12.3 in the bill, and it is glib. The meaning of without compensation means that owners are not compensated for the expropriation of their property. One cannot pay null rent, i.e. nothing, zero, null, but then claim that you have indeed paid compensation, but that the compensation was simply nothing. Section 12.3, what is considered when deciding on null compensation? This section provides what considerations may be considered when the expropriating authority elects to offer no compensation. The first matter is the issue of words, not to limit to. In a society governed by the rule of law as required by Section 1 of the Constitution, government cannot be granted a wide discretion on which factors must be considered when expropriating citizens' property and not paying any compensation. Legal certainty as an incidence of the rule of law requires that citizens are entitled to know what government may or may not consider when contemplating to expropriate property. The second matter is that the bill authorizes limitations on citizens' property rights for which no provision is made for in Section 25.3 of the Constitution. For example, Section 12.3.8 states that no compensation may be paid if the person is holding the property to only benefit from the appreciation of the property's value. Section 25.3a also states that the use must be considered when considering compensation. The Constitution requires that the use merely be considered in determining the compensation amount. It does not permit use it or lose it to become a lawful consideration for government to expropriate its citizens' property without any compensation. Once we continue, Chair. 5, the plight of homeowners. I don't see that they are quoting Section 25.8 of Section 25. Section 6 of the bill, because Section 25 said none of these provisions must, I'm just saying, advocate, no? must impede on government's land reform targets. Section 16 of the bill deals with property subject to mortgage as security for loans. Section 9(1)(d) provides that a government expropriates a property subject to a mortgage bond. It is to be expropriated free of the said mortgage bond. Section 16 of the bill states that the expropriated owner of the mortgage holder must inform the state of the mortgage bond within 30 days after the notice to expropriate is given. Failing which, the compensation is paid to the master. Section 18.3 states that if there is any dispute regarding a mortgage or deed or sale, the state may deposit the funds with the master. The expropriated owner and the mortgage holder will then have to approach the court for an order as to who is entitled to the compensation. This structure is not only arbitrary, but is manifestly cruel. This construction allows the state to take a person's home and deposit the compensation, if any, with the master, leaving that person destitute and fighting with the mortgage holder through litigation to claim the compensation which the person must use to find alternative housing. The state can leave countless citizens destitute by employing these bullying tactics, pitting citizens against one another to litigate about the compensation, if any, whilst their property is taken. The construction proposed in the bill is unfair and mean-spirited. It is also a great concern that the current version of the bill includes a new section, 12.5, which provides that the expropriating authority must consider outstanding rates and taxes and levies due to the property when it determines the compensation amount. Again, outstanding balances due to mortgage loans are not included. It is patently unfair for the state to bail out the debts due to itself in the form of rates and taxes while non-compensating citizens whose property are being taken, and to force these persons to repay loans for property that they no longer have, while also leaving the mortgage holder without security for these claims. We suggest that Section 12.5 be amended to at least include that the state must consider outstanding balances due to mortgage holders when determining the amount of compensation. It is not fair to leave citizens with debt for properties that no longer own. This section of the bill is also unconstitutional as it infringes on the citizens' rights to housing under Section 26 of the Constitution if this section is applied to residential property. Our positive law is inundated with case law where it was ruled that attaching or taking a person's residential immovable property must be the last resort and must be subjected to judicial oversight. These cases are Gondwana versus Sterco Development and others, Chief Lesapo versus Northwest Agricultural Bank and another, and Jafta versus Kuman and others, Van Rooyen versus Stolz and others. It is important to note that the Prevention of Illegal Eviction from Unlawful Occupation and Land Act 1999 states that a court considers an order of eviction. It must consider alternative housing available. Oh, after I'm speaking here. The occupier's personal circumstances, because they don't adhere to the same things that they are, circumstances and so forth. The bill, however, remains silent on these considerations and does not address the right of housing, which might be infringed upon the existing of exercising these powers. Last, the impact of this bill on the commercial banking sector must be considered seriously. Mortgages are determinant security vessel used by commercial banks to secure their lending. If those security rights are not protected, the bank will become more conservative in granting home loans, which will result in less access to adequate housing for ordinary citizens. It will also damage investor confidence in South Africa. The Banking Association of South Africa highlighted some serious concerns when it commented on the proposed amendment to Section 25 of the Constitution to allow for expropriation with no compensation. The direct cost of such a policy in the banking industry will amount to more than 1.6 billion in direct losses. These indirect costs are not specified, but the risk of damaging investor confidence and the bank's balancing sheets, as well as liquidity to fund large-scale investments, pose incalculable risk to the economy. A serious concern is that the downtown in land-based properties value uninitiated the 2008 economic crisis in the United States. BASA also warns that downturn in agriculture activity would result in greater hardship for the 22.3% of South Africans who live with food insecurity and 11.8% of South Africans who live in hunger. Any increase in these percentages is unacceptable and must be avoided at all costs. BASA also warned of the following consequences of expropriation without compensation. On the assets held in the banking industry, there would be an absolute reduction in property held as collateral. Property prices will fall. I will buy 12 then. And the risk of the banks to lend money will increase, will require banks to retain more capital and will trigger sovereign downgradings. On the banking industry liability side, there will be a reduction in foreign investment, which currently amounts to 368 billion of funding in the banking industry. All the above is evidence that the bill will severely prejudice the South African homeowner by potentially collapsing the banking industry, not only affecting the current homeowners, but the young citizens who buy property, pay off debts, and use their assets to leverage their way out of poverty, provide education for their children, and generally work for a better life. Urgent expropriations. Section 20 of the bill gives government the power to expropriate property on an urgent basis, which suspends the operation of the procedural requirements of Section 5, 6, and 7 of the bill. Section 20 shortens the process by allowing government to exercise the right to expropriate and offer compensation within 30 days of giving notice. The first problem with Section 20 of the bill is the provision that if the expropriated owner disputes either the expropriation or the compensation tendered by government, the dispute is resolved in terms of Section 19 of the bill. We refer to this as the expropriate. Now, argue later aspect of the bill. which is, in our view, unconstitutional. We argue that the same argument can be used to declare Section 20, subsection 5 unconstitutional. The second problem is the grounds of urgent expropriation contained in Section 22. Urgent expropriations are allowed when government declares a national state of disaster in terms of the Disaster Management Act 57 of 2002, or if the court grants such an order. It's important to note that the use of the word "or" in Section 22, 20 subsection 2, in that only the second grounds make provision for judicial oversight. A logical inference is that Section 22, 20 subsection 2A, urgent expropriation in a national disaster, requires no judicial oversight. We repeat the same concerns as above regarding the lack of judicial oversight. Section 20 subsection 2A is also of concern given that South Africa was in a national state of disaster for over 750 days since it was declared on 15 March 2020. It recently entered into a new state of disaster, which is still ongoing. If this bill were an act, government would have had unchecked expropriation powers for almost 1 calendar year without seeking judicial oversight in the expropriation of citizens' property and without complying with the procedures set out in Section 5, 6, 7 of the bill. The experience of states of disaster in our recent past shows that these can be extended multiple times, and there is a great risk that these powers might be abused. Conclusion. This bill must not, I cannot believe that I read the AfriForums. The bill must not pass.
I can continue?
No, it's just two paragraphs.
Continue then.
Lawmakers currently have their fingers ready to press the red trigger that will ruin the economy, cruelly deprive citizens of their property without judicial oversight, and destabilize the banking industry. The bill will hurt every citizen of every race, culture, and religion. If government persists with the mechanism of expropriation without compensation and persists with the expropriate now, argue a later mechanism, the bill is unconstitutional and can be challenged. Our rights to further comment remain reserved. Thank you.
Thank you very much, members. And that was the submission from AfriForum. So I'm standing between you and your lunch, and when we come back, the next it will be the we'll deal with the Agri SA submissions, and after Agri SA, it will be the Banking Association of South Africa.
Yes.
After it will be the FW de Klerk Foundation, and after it will be for SA for Faith and Freedom. Then missions. Before we go, I'm going to allow Mr. Ndu to give the synopsis of response for the Agri Forum.
Chairperson, I wanted to make this suggestion before we could actually proceed, because all this presentation have been made at the Select Committee. We have developed a comprehensive response to this presentation, the AfriForum, FW de Klerk, Agri SA. I was saying perhaps, for the sake of when we come back, we can actually go through them, and then I'll be checking the response that the department has actually crafted in terms of all these issues that then we project, we take it from there.
No, thank you very much. I was going to suggest when we sit down for lunch, I was going to be like a very nice person during lunch for you to look at your responses. And then as we come back, we sit down, you talk to us to the responses from one submission to the other. And so that we can be able to go to our own of the individual submissions to tackle that. Okay, so I'm going to allow all of us to go and eat lunch. And when we come back, if we can attend to it in that fashion, then we will have a fantastic day today and tomorrow. Thank you very much. Let's take a break to go for lunch, and we will come back. It's now 1:30. What time, members? It's 1:30, 2:30. Okay. We'll meet 2:30. It's an hour break. Thank you very much. The lunch will be served in the members' lounge. Again, let's adjourn until 12:30. Thank you very much. Let us continue. We are done with the AfriForum. And the next, it will be the Agri SA. Okay, from the Agri SA, I'm not going to look at every page. We are going to look at the summary of the submissions, and it goes like this. The interests of our members in the bill, we represent the largest grouping of agricultural landowners, and we want to ensure a sustainable and viable agricultural sector that we acknowledge the challenges of inequality, poverty, and unemployment, and the legacy of the land dispensation of the past. That the farmers of today cannot be held solely responsible for historical events and cannot be required to bear the burden of addressing apartheid dispossession disproportionately. Our support for free market principles and our view that expropriation should be a measure of last resort. That landowners whose land is expropriated should always have recourse to the courts. Reference is made to the study by GOPA Southern Africa Ltd on the potential economic impact and specifically the impact on capital information of the nil rent compensation approach. That most countries' laws require compensation in the event of expropriation, and we refer to the FAO study on best practice of compulsory acquisition. The tax implications in terms of the potential loss of tax revenue for the government is also pointed out, and the potential negative impact on food security is mentioned, and concerns regarding specific definitions and clauses, such as the definitions of expropriation and public interest and the nil rent compensation clauses. The expropriation bill in its current form will have a negative impact on our shared national commitment to building a more inclusive agricultural sector. It will weaken the protections afforded to private property, and this could see an exodus of capital from the agricultural sector and the broader economy. The anticipated loss of jobs and investment will impact both emerging and established producers alike. We also wish to highlight the importance of the public participation phase in this process and to emphasize the need for South Africans to be heard on this critical bill. We conclude that current landowners should receive prompt, adequate, and effective compensation, which will enable them to start anew somewhere else, and they should not be worse off as a result of the expropriation. That is the introduction, and specific comments for clause 1 on the definition of expropriation, and it says Agri SA has serious concerns regarding the definition of expropriation that was inserted into the previous bill at portfolio committee stage. The proposed definition limits the concept to instances where the state acquires rights in property. This definition excludes statutory limitations that undermines the economic utilization of property or dismantle its content from the concept of expropriation if they do not include the transfer of proprietary rights to the expropriator. In this way, the definition excludes constructive expropriations. The danger of narrow definition, I'm going to jump and just choose the paragraphs, some of the, yeah. Pardon? Yeah. Okay, the danger of a narrow definition such as the current proposal in the bill is that it may open the door for all kinds of government action that may severely limit property rights without compensation, or even acquiring property on behalf of third parties without compensation. The focus should be on the loss that the owner suffers, not on the acquisition by the government organs. Although the state had powers of expropriation before the present constitution was enacted, the state's current authority to expropriate vests in Section 25 of the Constitution. It should be noted that the Constitution itself does not attempt to define or limit the concept of expropriation. The Constitutional Court has the ultimate authority to make a binding interpretation of any provision of the Constitution. Should a court faced with a particular set of facts interpret the concept of expropriation as contained in the Constitution to the wider than a definition imposed by ordinary legislation, that provision would be inconsistent with the Constitution and can be struck down. Agri SA is of the view that the definition should be scrapped. This will allow the courts to deal with each case on its own merits. Alternatively, the definition must be wide enough to include all forms of expropriation recognized internationally. The exclusion of severe statutory limitations on the use of property from the concept of expropriation could have a negative impact on investor confidence and the growth of our economy. Clause 12, which is the compensation of expropriation. Agri SA believe that adherence to the principle of equivalence will result in the most just and equitable outcome for all parties involved. Agri SA views land reform as a national priority, and as such should be funded with general taxpayer money. Individuals belonging to one industry cannot be expected to bear the cost of a national priority alone. Landowners whose land is earmarked for land reform purposes must be placed in a position to continue farming elsewhere in a similar manner should they wish to do so. It should be clear that compensation paid to holders of unregistered rights is over and above any compensation paid to the owner and is not to be subtracted from compensation due to the owner. Point 6.3 on clauses 12, subsection 3 and 4. And okay. As stated in the introduction, the fundamental challenge with land reform is not necessarily at the compensation matter, but rather administration of the process. This has been recognized in a number of studies and reports, including the high-level panel report. The new clause 12, subsection 3 provides for expropriation at nil compensation, which may be regarded as just and equitable in certain cases. And then the Agri-Forum says there is no justification to expropriate land at nil compensation in terms of subclause issues. The property pose a health or safety risk. There are a multitude of other ways to protect the public against such dangers other than expropriating the land at nil compensation. Agri SA is particularly concerned about clause 12, subsection 4 that provides for possibility of nil compensation, where compensation is determined in terms of Labor Tenants Act. We question the inclusion of labor tenants in the categories of land identified for possible expropriation at nil compensation. We do not believe that it is justifiable to take such land without compensation. The Land Reform Act is a complex piece of legislation. The definition of a labor tenant has been the subject of many court actions. The main problem with the legislation has been the Department of Rural Development and Land Reform's inability to implement the legislation, not the issue of payment of compensation. This was highlighted in the high-level panel report on key legislation as well as a judgment in the Mvelase case. The Director General of the DRDLR's testimony in the Mvelase case is very interesting and points to the complexity of the implementation of this legislation. (6.4) Clause 22, which is service and publication of documents and language used therein. In terms of clause 22, subsection 4, it is specified that the delivery contemplated in subsection 3 must take place at the address in question by A hand, B, fax, provided that a confirmatory copy of the document is sent by ordinary mail or by other suitable method within 1 day of such transmission or registered post. It is suggested that given the importance of the processes involved in intended legislation, delivery should be affected by means of service by the sheriff. In many of our rural areas, delivery of mail is problematic, and in some instances, non-existent because of the distance of towns where postal services, if available, are situated. Mailboxes might not be regularly attended to, and as such, the property owner that receives a document via ordinary or registered mail might be prejudiced due to the time frame involved. What might be regarded as a default on the side of an owner is basically just an inability to react timelessly to a notice that is, in most instances, that person is not even aware of. Facsimile transmission, although still utilized in some instances, in an outdated means of communication. It's an outdated means of communication. Given the respective options of delivery available in terms of this laws, it is submitted that most of the options provided for are unreliable, hence the suggestion that service by a sheriff should be applicable. And in conclusion, experience in other countries has shown that expropriation does not speed up land reform significantly, nor does it make land reform more affordable. In fact, the contrary seems to be true. Expropriation does have a limited role to play in land reform, but only as a measure of last resort when expropriation is utilized. It should be perceived by all to have been preceded by a fair and transparent process. Safeguards should be put in place to prevent any misuse of the power to expropriate. Current landowners should receive prompt, adequate, and effective compensation, which will enable them to start anew somewhere else. They should not be worse off as a result of the expropriation. The full cost of expropriation should be borne by the fiscus. Individual landowners cannot be expected to foot the bill for land reform through reduced non-market related compensation. In the interest of the future of this country, government should nurture the agricultural sector. Agri-SA requests an opportunity to address the National Council of Provinces on our views and concerns on this critical piece of legislation. That is the submissions from Agri-SA. Mr. Ndu?
Okay, thank you, Chairperson. I'm going to read the responses that we have crafted as a department in relation to these inputs that were made by AfriForum, Agri-SA, I think together with the foundation, FW de Klerk Foundation, Faith and Freedom. I think, you know, most of the things that are actually covered there.
Let's do this way. Before you go on, let me highlight just the highlights of that. So then we are done with them. We know that now we are.
Yeah, that's fine.
Because I did only one. I didn't do the other ones. From the FW declare, also I am going the summarized version. I'm going to create the summarized version. Okay, so Section 25, so the foundation agrees that there is a need to adopt a new expropriation act that will conform with the requirements of Section 25 of the Constitution. However, for the reasons set out below, the present expropriation bill not only fails to provide an appropriate framework for expropriation, but is irreconcilable with the values that underlie the Constitution and would have very negative consequences for all the people of South Africa. Section 25 states that is English. Section 25 states peremptorily that no one may be deprived of property except in terms of law of general application. No law may permit arbitrary deprivation of property. In the foundation's view, and in terms of simple understanding of the English language and degree to which compensation for expropriation falls below reasonable and unmanipulated market value of the expropriated property represents deprivation of property. The degree to which a law to deprive people of their property would be arbitrary will be determined by whether it will be reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. In assessing whether a law is arbitrary or not, the following requirements in Section 36 of the Constitution would have to be considered: the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relationship between the limitation and its purpose. Less restrictive means to achieve the purpose, but rather incompetence and corruption in the government's administration. So the foundation's principal objection to the bill is that although an EWC would likely be used to target primarily the property rights of white South Africans, it would undermine the property rights and freedom of all South Africans. It would in particular pose a threat to the 8.5 million Black households that own their homes and the millions more households that occupy land in their traditional areas without proper title deeds. It is for the above mentioned reason that the foundation considered view is that the bill fails to meet the requirements of both the Constitution and the rule of law. That's the summarized version. I'm done with that one. And next is the Banking Association of South Africa. So, just a second. I want the summarized version of, okay. Let's do this. So, page 6. On page 6, yeah. On page 6, on more detailed comments on expropriation bill, on chapter 1, definition and application, holder of a right, the definition is not updated to include holders of registered rights, but have added an exclusion for unregistered owner. It is not clear whether the exclusion pertains to purchasers not yet registered or owners of rights to property that is not yet registrable. So they are indicating some of the words or the language that has been used in the bill. And they didn't, some way they don't include the clauses. But as you see that the concern of the interpretation is raised mostly from their submission. The recommendation from them is that we recommend that the definition of a holder of a right should read means a holder of a registered or an unregistered right in property. Land parcel, that's another definition. Land parcel is updated in some provisions, but still not used consistently. Land and land parcel are still used interchangeably without including a definition for land to clarify the distinction. We support the definition of land parcel and are of the view that this wording should be used consistently throughout the bill for clarity of interpretation of all provisions. Recommendation, if the intention of the bill is to apply an alternate interpretation when referencing land, then land should also be clearly defined. Next, owner. It is unclear whether the current definition of owner is intended to include a holder of registered rights in property, such as a bondholder, although it appears that it might. It is important to understand whether this is the case and for the wording to clearly define this as so. As subsequent sections in the bill specifically reference to the rights of owners and holders of unregistered rights and do not include the reference to holders of registered rights. As an alternative to our recommendation that the definition of an expropriated holder and a holder of a right be amended to include registered rights holders, it is imperative to clarify whether owner includes the holders of registered rights. It is also imperative that definitions are used consistently throughout. For example, section 7, subsection 2H, I invites any person who may be affected by the intended expropriation to raise any objections to the intended expropriation. The recommendation is that the definition of owner to be amended as follows with a concomitant addition to a definition for real right. Owner means the owner of property or the holder of a real right in property at common law. And where the ownership of the property or real right is questioned is registered, means the person in whose name such property or real right is registered. And real right includes any right which becomes a real right upon registration with the appropriate registration authority. Property is defined as property as contemplated in Section 25 of the Constitution, which definition does not limit property to only land. While we support an interpretation that property should include both registered and unregistered rights in land, we do not support a broader application that could include intellectual property or personal rights. Recognized types of property include 1, movable and immovable property, 2, tangible and intangible property, and corporeal and incorporeal property. South Africa recognizes certain types of rights in property. These are real rights, which apply to immovable and movable property, which is land and improvements, shares in companies, usufructs, etc. Personal rights, for example, personal security, liberty, etc. Immaterial property rights, which apply to intellectual property. Limited real rights, which refer to a restrictive right that a person has over another's property, e.g. a servitude. Statutory rights, which refers to legal rights created by the state throughout the legislation. Recommendation, the bill should be aligned specifically to the references made to land reform and equitable access to all South Africa's natural resources in Section 25, subsection 4A of the Constitution. Therefore, the definition of property should be restricted to only reference, registered and unregistered rights in land parcels and equitable access to all South Africa's natural resources. The bill should therefore provide a definition of property beyond merely referring to Section 25 of the Constitution. The definition should explicitly define the classes of property that can be expropriated. Next is the public interest. Public interest is defined in the bill as includes the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources in order to redress the results of past racial discriminatory laws or practices. We submit that this definition should be redefined within the context of Section 25, subsection 2 of the Constitution as follows. Public interest could be interpreted to include both for-profit and not-for-profit entities outside of land reform and reforms that bring about equitable access to South Africa's natural resources, where beneficiaries would benefit from for-profit initiatives. Public interest should otherwise be restricted to consumptive and non-profit use purpose only. This could be in accordance with the principles of fairness. This would include public facilities, public welfare undertakings that do not aim for profit, but rather to serve public, and where benefits are shared by society, e.g. roads, military installations, public facilities, government buildings, etc. Any other land use should be excluded from scope of land expropriation. Private and public companies, as per the definition in Chapter 1, Interpretation, Purpose, and Application of the Companies Act 2008 and amendments thereto, that generate profits are not allowed to expropriate property and natural resources to generate profit, but can acquire such property and natural resources through the normal operations of the market. Similarly, state-owned companies that generate profits should not be allowed to expropriate property and natural resources in order to benefit from such expropriation for profit generation purposes, but should only be allowed to expropriate property for if the proposed definition of public interest is met. Third-party transfer that benefit a private person, exclude land reform, equitable access to natural resources, but which does not benefit the public in any way should not be allowed. And the minister, the court should always ensure that this is the case in any expropriation that seems to benefit the third party. Further expropriations that benefit the third party that provides a public utility should only be allowed as far as they satisfy the public interest requirement. The recommendation, the definition of public interest should be aligned to Section 25, subsection 4A and B of the Constitution. We therefore recommend the definition of public interest should be amended to read includes the nation's commitment to land reform with an obligation on the state to take appropriate measures to ensure that equitable land reform is for the benefit of the recipients of expropriated land, to empower them with access to capital, skills, and resources to successful as further prescribed in the regulations to the bill and to reforms. The insertion into the bill, the owner or owners of the remaining portion of the property, adjacent property, have the right to request that these properties be expropriated if the initial expropriation negatively impacts on the market value of their property or properties. Disputes as to whether the initial expropriation has impacted on such property values or expropriation compensation levels are to be resolved through the courts. Interpretation, again, public purpose. Recommendation, the definition for public purpose should be aligned in section 25, subsection 2 of the Constitution, and should also include circumstances provided for in the current Expropriation Act 1975 and related land tenure and restitution of land rights legislation. Moreover, there is a need for clarity to ensure conformity with section 25, subsection 2 of Constitution, which demonstrate public necessity. Constitutional court cases FNB versus SARS 2002, Bissett versus Buffalo City Municipality 2003, and amongst others have reference. A provision for regulations which detail qualified activities for public purpose should be added into the bill. We recommend that the definition should be amended to include any purpose that results in an outcome of economic development for the recipient of land expropriation and the economy connected to the administration of the provisions of any law by an organ of state. In addition, we recommend that regulations which articulate the proposed definition of public purpose are drafted. Okay, are drafted, that's a full stop. And okay. Another indication is for the application of the Act, the section 2.2, we talked about this. The bill remains vague around the meaning of without success. How will it be determined if the expropriating authority has without success attempted to reach an agreement with the owner? The bill should clearly state what process should be followed to demonstrate that no agreement could be reached with the owner or holder of an unregistered or registered right. We recommend that phrase without success be deleted and the following phrase be added at the end of the clause. And the parties have failed to reach agreement regarding the acquisition. Chapter 2 on the powers of the minister to expropriate. This section provides that ownership of property expropriated by minister will vest in the state. Recommendation, we propose that clause be added that emphasizes that the expropriated property must be used for the purpose it was expropriated and that it cannot be used for any other purpose without the state reviewing the amount of the compensation paid to reflect just equitable compensation based on the alternative land parcel use. Section 3, subsection 5A, this section is in contravention of the Deeds Registries Act 1937, as it provides for ownership before transfer of the property is affected. There's no alignment to the requirements for the valid transfer of immovable property. Although it is acknowledged the ownership can vest by operation of the law, we believe that the current well-established system of transfer of ownership as contained in the Deeds Register Act is the appropriate method of determining ownership. Additionally, the section provides for no alignment to the requirements for the valid transfer of immovable property. The recommendation is the ownership of the property vests in the relevant organ of state on the date of which transfer of ownership of property is registered by the relevant Deeds Registry Office in terms of the Deeds Registry Act 1937. The words of expropriation should be deleted. Section 3, subsection 5B. We recommend that possession should only be given on transfer of ownership to the relevant organ of state and not prior to that. Recommendation: possession of the property will vest in the relevant organ of state on the date of registration of transfer of ownership of the property in the name of state. Investigation, Chapter 3, investigation and valuation of property. I'm just going to go straight to the recommendation that this clause to read as follows: the existence of registered and unregistered rights in such property and the impact of such rights on the current and intended use of the property. And we believe that the consent of the owner must be obtained and that in the absence thereof a court order should be obtained. Here and in numerous other sections, we recommend that the words "if the property is land" be removed. Our previous request that the definition of property must be limited to land or immovable property refers. Recommendation: this clause to read as follows: subject to subsection 3, an expropriating authority must, with the prior written consent of the owner or an applicable court order in writing, and it continues on that clause. And section 5, subsection 4A, recommendation is that the documents needs to be limited to those required on valuation to be undertaken, those that are not subject to legal privilege. Confidential of the subject of a dispute. The Property Valuation Act 2014 states that the valuer must write a report which must be made available to the owner. The availability of such a report to the owner, registered and unregistered rights holders should be included in the bill. We believe that value of the property is affected by intended expropriation. As soon as expropriation notice is published, a property's market value is impacted. We therefore recommend that the evaluation process should commence prior to the publication of expropriation notice in terms of section 7, so that the value of the property is not unnecessarily negatively affected. Okay, the valuation of the property will materially guide the state in objectively determining whether it should proceed with an expropriation notice. And as for section 5, subsection 7, this section refers to the property being repaired to a reasonable standard. If it has been damaged, it is not clear what a reasonable standard entails in this context. The recommendation is that the section be rephrased to read: if the property in question is damaged through an act contemplated in subsection 2, an affected person may deliver written demand to the expropriating authority, and the expropriating authority must confirm within 15 days receipt of well as the acceptance of notification. If the expropriating authority has accepted the written demand, the expropriating authority must repair and or restore the property to the state it was in prior to the damage taking place within the confines of the National Environmental Management Act and any other environmental legislation with similar requirements, and compensate the owner to repair and or restore the property to the state it was in prior to damage taking place, or compensate the damage within 90 days after the above notification date. Section 7, which is the intention to expropriate and expropriation of property. The bill contains no expression provisions regarding property owner rights holder challenging the expropriation itself. The recommendation is that the bill should expressly provide details concerning the process to be followed for a property owner rights holder to challenge the expropriation. Section 7, recommendation: filing notices of intention to expropriate a property with the Register of Deeds is recommended to allow banks to timelessly identify potential risk and losses. Section 7(1)(a), as previously highlighted, there is a need for the holder of right to include a reference to registered rights. This section has been updated to include mortgagee, which is Welcome Chair to Expropriation Act 63 of 1975, as well as prior versions of this bill. Recommendation is this law should read as follows: 7, notice of intention to expropriate on the owner and any known holder of right in their property and on the registrar of deeds. And what is going on? I'm sorry. Just a second. I just want to look at the. Okay. So in conclusion, upon reviewing our members' position, I didn't all the sections because I feel like I'm repeating one and the same thing that AfriForum have said, the Agri have said. So the conclusion from Managing Director Bongi Kunen is that upon reviewing our members' position regarding the legislation, there is a need for thorough consideration of the operational impacts and processes that will need to be managed when this bill is promulgated as an act. We reiterate that the envisaged expropriation intervention should not dilute property rights or be applied injudiciously, failing which local international investor confidence in property as an attractive asset class will be undermined, and which in turn could destabilize the financial system, distract from benefiting intended beneficiaries, and ultimately threaten the greater economy of the country. The expropriation bill is an extremely important key piece of legislation where a uniform approach to expropriation, prudence, and objectivity in its implementation is essential. The bill therefore needs to provide crisp and clear policy guidance to some 255 state entities who are empowered through legislation to expropriate property, together with property owners and rights holders alike. As we have demonstrated in our comments, the bill is ambiguous and silent in several key areas, and in parts it conflicts with existing legislation. We therefore urge the department to comprehensively review the bill to remove any policy uncertainty. As the need for aggrieved expropriated owners, rights holders to resort to the courts for guidance will exacerbate what is already sensitive and emotional matter. Additionally, we are of the view that it is also important for the bill to also consider envisaged legislative land reform processes, including, among others, the Land Court Bill, the Preservation and Development of Agricultural Land Bill, and the Land Donations Policy. That was the conclusion for the Banking Association of South Africa. Okay, and then for faith and freedom. For faith and freedom, page 14. Okay. Okay, for the I'm sorry, let's have a look at this. Okay, for for faith and freedom, the recommendation, I'm going also to go to the recommendation because also they mentioned the same. No, it's not copy and paste, is it? Don't. And from their submissions, it's not Mr. Maseko. So need to write that down. I checked this morning.
I'm not saying that so me is a copy and paste. I'm saying these organizations, because if you look at that, specifically 41.3, it's exactly the same which is in AfriForum's
Where are you? Are you in for SA, for Faith and
Yeah.
Freedom?
Yeah, for S, yeah.
And then you say which one, it looks the same.
43, it's on page 14.
Page 14.
Yeah, 41.3. The one of the COVID pandemic. And also power supply experienced by ESCOM. It's exactly the same which is in the AfriForum.
Yeah, it happened the same way where they are staying and where I'm staying.
Maybe they are using the same lawyers.
I'm not going to cast aspersions to
I-
people.
I found this in
don't
school
want-
too. When I was a teacher, where the children will copy the name of the guy where they copied it from too.
So if I was a grade 1 teacher, I will say,
It was referenced.
member, sit here, and you sit there. And then you sit there. But you are members. I'm not in the grade 1. So we are going to continue so nicely and say, Mr. De Villiers, I see on this one, there are some issues that are not in other submissions. So we have to go through it because it's not the same, like you say.
The recommendations on page 14 and 15. They go to specific clauses.
Yeah, they do recommendation, but because we haven't looked at what is there, we can't go to recommendation if the thing is new, we don't have it. So member De Villiers, because it's got a lot of energy. You are the one leading us on this one. Yeah, from the page 1. They are going to do from 3, the next page, start on the 3 on executive summary of submissions.
We hereby submit our concerns relating to clauses 1, 12, and 20 of the bill. In brief outline, our submissions are as follows. 4.1. Our understanding of the general objective of the bill is the expropriation of land and certain land-related property rights. However, the definition of property is not limited to land. Neither do exceptions for certain types of land, specifically land used for religious purpose, exist. Without this limitation, property could mean anything from land to the clothes on a person's back, or even the intellectual property. The Constitution protects the fundamental right and religious freedom, which includes the right to practice one's faith in a community and form, join, and maintain religious associations. A right one may not be denied. Furthermore, the state is bound by these rights and constitutionally mandated to respect, protect, promote, and fulfill these rights. While we applaud the inclusion of listed criteria, which must be considered before expropriation without compensation, can occur, we object to the list that not being a closed list and or that no exceptions to property that cannot be expropriated or provided for. Although well-intended, the broad definition of property, the open list for EWC, and the absence of any exceptions will have unintended and potentially disastrous consequences, including the potential expropriation of church land and or land used for religious purposes. In the circumstances, we propose that 5.1, the definition of property in clause 1 be limited to land and appropriate affected land-related property rights. 2, the definition of public interest in clause 1 be aligned more with the Banjul Charter by including to meet a public need. That the definition reads as follows. Public interest includes the nation's commitment to land reform to meet a public need and to reforms to bring about equitable access to all South African natural resources in order to redress the results of past racial discriminatory and laws of all practices. The clause 12.3 be removed. Alternatively, that the criteria for EWC in clause 12.3 be a closed list. Clause 12.4 be removed. Alternatively, all the relevant circumstances be defined and or linked to the list in clause 12.3. That an exemption clause is inserted which sets out with which land is exempted from EWC. Here we specifically purpose land that is owned and used in connection with the exercise of the constitutional right to religious freedom and the rights of religious communities is hereby exempted from applicability of sections 12.3 and 12.4. And clause 20.2a be removed. Alternatively, that express provision is made for judicial oversight in the exercise of clause 22.2a. We also urge the committee to approach the Constitutional Court for a declaratory order regarding whether the no compensation bill will qualify as just and equitable payment. This will achieve clarity regarding whether EWC, as proposed in the current version of the bill, is constitutional under section 25.8 of the Constitution. We request an opportunity to make verbal submissions in this regard during any further consultations that may be held concerning the bill. And so on and so on and so on.
Member de Villiers, you may continue. Thank you very much.
8. About for South Africa and our interest in the bill. Freedom of religion in South Africa, NPC, then the number for South Africa is a legal advocacy organization working to protect and promote the constitutional right to freedom of conscience, religion, thought, belief, and opinion. Religious freedom in South Africa. For South Africa currently has an endorsement base of religion leaders representing millions of people in South Africa. Its constituency spans across various denominations, churches, and faith groups. For example, in the lockdown matter, for South Africa was mandated by religious leaders and organizations representing between 11 million and 18.5 million people from cross-spectrum of churches, denominations, and faith groups, including 10 million people from the African, indigenous, and spiritually churches to engage with government and make submissions on their behalf. As such, and because the constitutional rights to freedom of conscience, religion, thought, belief, and opinion, and to practice one's faith in a community and form, join and establish religious associations are directly affected by any law, and that could potentially affect the ability of the millions of believers in South Africa to meet together in buildings located on land in the exercise of their constitutional rights. Our constituency has a direct interest in this matter. The state has a duty to respect and protect the religious convictions and beliefs of those believers who choose to meet together to practice their faith. Procedural concerns. The Constitutional 18th Amendment Bill aims specifically to amend Section 25 of the Constitution, allow expressly for EWC. On 7 December 2021, the Parliament of South Africa rejected this bill. Given that the Constitution has specifically not been amended to allow EWC, passing a subsidiary legislation would immediately open up the bill to a constitutional challenge for being inconsistent with the Constitution. Parliament has expressly chosen not to amend the Constitution to allow for EWC. For this reason, Parliament cannot give the Minister of Public Works and Infrastructure the power to expropriate property for no compensation. To the extent that the bill includes provisions to this effect, it is arguably contrary to the rule of law, which requires the government operates within the powers conferred on it by the Constitution. Government derives its power from the Constitution, and with the Constitution expressly not being amended to allow EWC conferring such powers on the minister would be illegitimate and contrary to the rule of law's principle of legality. For South Africa, therefore, urges the committee, alternatively, the Western Cape Provincial Parliament to approach the Constitutional Court for a declaratory order regarding whether the null compensation to be paid, as proposed in clause 12.3 and 12.4 of the bill, would qualify as just and equitable payment, and thus whether EWC is constitutional under section 25.8 of the Constitution as it currently stands. Any measures taken by the state concerning socio-economic rights must pass the constitutional standard of reasonableness. Parliament is now set to craft and promulgate a new legislative measure which will have a wide reaction effect on the nation. All while the issue of EWC has been and remain hotly disputed. For this reason, for South Africa is concerned that the first port of call should be to ascertain from the Constitutional Court whether EWC is constitutional or not. To do otherwise would be putting a cart in front of the horse and risk falling in short of the set standards of reasonableness. Legal framework, international law, in terms of the section 39.1b of the South African Constitution, a court must consider international law when interpreting the Bill of Rights. In addition, section 232 of the Constitution states the customary international law is law in a republic unless it is inconsistent with the Constitution or the Act of Parliament. 21. Finally, section 233 of the Constitution requires that every court, when interpreting any legislation, must prefer any reasonable interpretation that is consistent with international law. It would thus be prudent for Parliament to adhere to the constitutional imperative to heed applicable international law when drafting legislation that affects fundamental rights. Treaties and declarations. South Africa has signed the following international and regional.
Sorry, member.
Thank you.
Can you,
Thank you so
go? No, you're not done.
And so on and so on.
Go to, no, you are not done. Can you go to now start from the comments relating to the substance of the
Page.
I will tell you just now. It's page 11, yeah.
Comments relating to the substance of the bill.
Yes.
Clause 1 of the bill. Clause 1, definition of property. 36.1. Property is defined as property contemplated in section 25 of the Constitution. Section 25, 4.4b of the Constitution states that property is not limited to land. Legal theorists have suggested that property should be understood to mean property rights. Example, the legal relationship to a thing, and then they describe it there. As a result, all property from immovable or to trademarks becomes encompassed by the bill and subject to possible state expropriation. For South Africa is the view that this definition should be specifically limited in the expropriation bill, as the bill clearly intends to deal with and relate to immovable property and appropriate affected land-related property rights, not intellectual property or shares. Clause 1, definition of public interest. Currently, the bill defines public interest merely as including the nation's commitment to land reform and to reforms to bring about equitable access to all South Africans' natural resources in order to redress the result of past racial discriminatory laws or practices. Number 2, for South Africa submit that this definition should be aligned more with the Banjul Charter by including to meet a public need. Example that the definition reads as follows. Public interest includes the nation's commitment to land reform to meet a public need and to reform to bring about equitable access to all South Africans' natural resources in order to redress the result of past racial discriminatory laws or practices. We submit that absent clear definition in respect of the foregoing terms, the bill is in danger of being open to abuse by future political dispensations. Clause 12, should I go on? Thank you, Chair.
Thank you very much, member. I really appreciate your help. And we are on clause 12 of the bill. Clause 12, subsection 3, it only relates to land and provides that where land is expropriated in the public interest. And it may just be an equitable for nil compensation to be paid where land is expropriated in public interest. That is a quote from the bill itself. And 39.2 is for SA strongly objects to the list not being a closed list and or that no expectation to property that cannot be expropriated are provided for. 39.3, furthermore, given that Parliament rejected a bill aiming to amend the Constitution to provide for EWC a little less than a year and a half ago, it is highly doubtful that clause 12.3 will be, clause 12 subsection 3 will be seen as being reasonable due to the bill legislating a likely unconstitutional provision into law without attempting to obtain clarity regarding its constitutionality from the Constitutional Court first. Okay. So clause 12.4, again, we saw that also in, I'm not going to read it. Agent expropriation already, Mr. Ndu dealt with that from the Western Cape government. Clause 20.2 also that was talked to. And the recommendations from here is the definition of property in clause 1 be limited to land and appropriate affected land related property rights only. The definition of public interest in clause 1 be aligned more with the Banjul Charter by including to meet a public need. It is that the definition reads as follows: public interest includes the nation's commitment to land reform to meet a public need and to reforms to bring about equitable access to all South Africa's natural resources in order to address the results of past racial discriminatory laws or practices. So they inserted to meet a public need. And that clause 12 subsection 3 be removed. Alternatively, that the criteria for EWC, which is the expropriation with compensation in clause 12 subsection 3 be a closed list. For 2.4, they say that clause 12 subsection 4 be removed. Alternatively, that all the relevant circumstances be defined or linked to the list in clause 12 subsection 3. And next, that a clause containing land which is exempt from the expropriation without compensation be inserted. Here, we specifically propose land that is owned and used in connection with the exercise of the constitutional right to religious freedom and the rights of religious communities is hereby exempted from the applicability of sections 12, subsection 3, and 12, subsection 4. Clause 20, subsection 2A be removed. Alternatively, that express provision is made for judicial oversight in the exercise of clause 20, subsection 2A. And we also urge the committee, alternatively, the Western Cape Provincial Parliament, to approach the Constitutional Court for a declaratory order regarding whether the nil compensation as proposed in clauses 12 subsection 3 and 12 subsection 4 of the bill would qualify as just an equitable payment. This will achieve clarity regarding whether expropriation without compensation is constitutional under Section 25, subsection 8 of the Constitution as it currently stands. And that is the end. Thank you very much, gentlemen. And a lady. And the city is done. I think that was the last, Mr. Ndu.
Chairperson, I think that's the last one that we have
received.
responded to.
Okay.
Let me proceed with the
Yes.
responses that we have provided as a department in relation to those inputs that were made.
Okay.
Chair, maybe before I could actually respond, let me also put forward to say, after the department finalized the bill, we send it to Parliament, or we introduce it to Parliament for parliamentary processes. So some of the changes that you're seeing here, they're the changes that have been effected by the portfolio committee when they're doing their own public participation process. And as a department, we are not allowed to change. It's not change when it's going through these processes. So that's why you'll find some of the things it's very difficult for us to actually give answers to on the basis that they came as a result of the consultation by the portfolio committee through the National Assembly. Remember, it's a Section 76. It has been considered by the National Assembly and also the NCOP. But be that as it may, it does not necessarily mean that we should not actually provide the rationale as a department. That's why also initially I was saying we noted, because it's in your hands. You have to actually make a final determination in terms of what you want to see. Be that as it may, Chair, in terms of the issues that have been raised by those critical stakeholders that we have actually read their inputs, we divided our responses into now, I think, 11 thematic areas. I've spoken to that before. I was looking for this document. We have also provided this document to the NCOP in the select committee. I think a week ago, we had an engagement with the stakeholders. Both of them, they came, they did their presentation. We were there with our senior councillor as well. So the first one that we look into was the definition of deliver, because it was also contentious there, registered post, and the tension with clause 22. Chairperson, I think Agri South Africa and Banking Association of South Africa proposed that clause 22 provide for the delivery by email. I think, initially we were talking about the traditional method. So we raised this issue before as well when we engaged in with the portfolio committee. And it came back. And I think, the issue that is coming back now, it shows to say that I think, what has been covered by the bill itself as it stands, it doesn't actually cover the spectrum of our society. So we must be alive to the reality and look into what could the best method that we can use to engage with our people. So email from our side, we're writing it to say that we are supporting it, and other innovations that could actually be used to actually communicate and actually save the notice. So we've put that to say that the department supports that. We have actually flagged during the National Assembly, but in one way or the other, when they're actually processing, it went out, it did not actually find an expression. And we say the fact that is coming every now and then in these both houses, it shows to say that there's something that has to be looked into, and hence we are supporting that as well. I think the issue that we're just qualifying, we were reflecting to say that, yes, it's true, to deliver the emails and other modes should actually be included. So we are in support of that as a department. And I think that could be, part of your issues, yes, that you flagged there. Chairperson, I think I won't actually read. We have qualified. I think we have put about 15 statements that actually qualifying why it is important for us to actually consider other means of communication instead of actually focusing on the post office. Qualify the state of our post office to say perhaps in one way or the other we're going to have problems. So there are a number of things that we've written around that. So that's the first one in terms of the delivery. We're accepting that, and we're saying we can use the other means of communication. The second issue is clause 2 and definition of expropriation, and the issue of excluding the third-party transfers. I think BASA, commented on the third-party transfer in the public interest for land reform purposes. And And I think they did so in relation to the definition of the public interest. But we are seeing some shortcomings in the bill. And initially, we advised as well the portfolio committee to say that I think, there are shortcomings that we have to actually look into, particularly in relation to this issue of the public interest. That's why, initially when we're saying perhaps, the definition of the public interest should be relooked into. But when we're looking into the public interest, we must not actually forget the supreme law of the country, so that we can't actually craft a definition that is outside of the scope of the Constitution, because that would actually be rendered unconstitutional. The Agri-SA, again, Chair, made a point around the Constitutional Court interpretation of Section 25(1) and 2. And I think they were making emphasis on the issue of deprivation to say that how do we then actually, define that versus the expropriation without compensation. I think, we consulted a bit around the issue of public interest and public purpose, and subject to compensation. We then actually went on and say what amounts to public interest, what amounts to public purpose, and what amount of compensation should actually be accrued on the basis of those definitions that were actually reflected there. So in the main, again, we then said the Constitutional Court as the highest decision-making body, although we didn't actually flag in the body, should actually, make a determination of what amounts to public purpose and public interest. I think I like the contribution that I've made about the Land Court Bill. I just actually raised it in passing to say the issue of Land Court Bill is coming on the basis that if you check a lot of issues that are contentious in the bill, we are saying we are referring to the court as a final arbiter. So if you don't have dedicated courts that are going to actually look on land-related matters and include expropriation as well in the process, we'll actually have this backlog maybe for the coming 40 or 50 or 100 decades, I don't know. Hence, we're saying the Land Court Bill is also critical. If you check on it, it includes some elements of expropriation specifically. So we'll have dedicated, legal personnel that are going to actually deal with expropriation matters. So these matters are going to be given, prominence, and therefore they are going to be addressed as soon as possible. And depending that we have actually failed to engage and reach amicable solution before we could actually get to the angle of the courts. Chairperson, like I've said, we have written, I'll share this. I'm just actually zooming to the thematic areas that have been actually covered as per presentation that actually came there. Again, the other issue that we have looked into is the definition of expropriation. I think it's clause 2. And if I'm not mistaken, I think it's the foundation, FW Foundation, they talk about constructive expropriation. It's not expressly included in the bill itself. And I think also BASA, reflected that as well. And we then said, yes, I think NCOP should actually look into that matter and see how best they can actually address these constructive or indirect expropriation as alluded and proposed by these two foundations. But also the question of jurisdictions, should be considered when we're actually making that particular determination. So we wrote also a comprehensive, I think it's about 4 pages. I'm not going to actually read, I'll make that available as well. So we have attempted to answer that particular question raised by FW Foundation and Agri-SA. I think they were also supported by race relation. I think in your context, you did not actually get an input from race relation. Here we got it, and we have done some case laws as well to actually support the answers that we've given. So I think this answer could assist. Again, the definition of property, I think it cuts across. If you check all the presentations there, they were talking about a property, but what stand out was the question of whether the property that we're actually talking about includes the intangibles. So we needed to actually provide an answer as to whether it's including that. But you see, again, the answer is quite broad because it refers again to the Constitution and say we defining property as contemplated by Section 25 of the Constitution. So I think one of the submission is that in the property definition, like other definitions that were spoken about, should actually be relooked into. And maybe, the NCOP can craft a simpler and better understood definition of what amounts to property, whether it includes intangibles or not. Not at all. Again, we look, the definition of the public interest, because I think it came very strongly. And you check, there this in a broader sense where it's limited to the question of the land reform. So the person is saying, does public interest only extend to the question of the land reform? It doesn't actually transcend those borders. So we then actually again, because these are common questions that are actually coming at at all the stages. Yeah, so the advice that we're getting, because for example, even if one try to be very innovative, but if you go to legal experts and if you go to constitutional experts, then they confine themselves to the definition that are there in the Constitution. It becomes so difficult for us to actually go beyond that. We'll confine ourselves in terms of that. But these questions are always coming. And the answers that, because even here, they're still referring to the Constitution, Section 25, to say that the definition is derived from there, and public interest there is more the covering the question of the land reform and also the just and equitable access to natural resources.
Won't that be a little bit difficult for you, because you have to now develop the regulation, and there is that issue that the referral goes to the Constitution, but the interpretation from the legal gurus also, it's hanging. Is that cloud hanging above you? Will that be easy one way or another for you, or it's a challenge that you identify?
Chairperson, I think that's the challenge that we've identified, but that's why when we develop regulation, because regulations are supposed to be very, very clear, we must actually interpret them the same. So the nuts and bolts of what is not actually coming very clearly here must be very clear on the regulations. So I'm saying from where we seated, we have all these inputs that are actually coming. Some of them are, like saying earlier on, we're saying this one qualifies better to be in the regulations. So we're going to draw that explicit, that clearly and put them in the regulations. But remember, we'll need to test them. That's why they're also saying clause 12.3. Can't we actually test it while it's still here with the Constitutional Court as to whether they are meeting the constitutional master? So it's the call that the lawmakers are making. But from where we seated, we'll throw a statement there to say that this is what we're thinking around the areas covered by the Constitution. But then those who are actually working with that within that field should actually validate and test that further and check as to whether they are in line with the Constitution of the country. I agree with you to say that if, for example, some of the issues are not actually flagged, they might actually present a challenge when we develop regulations. But from where we seated, because we have all these challenges that are actually surfacing there and there, we'll actually pin the regulation on the basis of the information that we actually got, and then we send them for inputs. And then again, we'll need advices as well in the process. And the Office of the Chief State Law Advisor, remember, you won't go to the second stage if whatever you've actually proposed is not in line with the Constitution. But they check in one way or the other, and we get the certification on the basis of aligning our take with the Constitution of the country.
Sorry, Honorable Ma'am. I say it becomes a permanent problem because your regulation is going to be based on which interpretation?
You see, that's what I'm saying. These two houses, because remember, you are seized with this bill now, and these are the challenges that and it's on record. Hence, when we respond on one of the things that you're raising around the issue of delivery, we as the department, we raise it, and we said let's be alive to the contemporary, activities that are happening in the world. But then it came differently after it has been processed, by the National Assembly. And then they're sponsoring a draft, and we're seeing these challenges as well. We thought, on the 24th, when we engage, I think honorable member said he would like to attend as well. Yeah, because these are the things that are going to actually come there. And then, as lawmakers at that particular level, they should actually make a final determination and informed by research and some legal advices that they actually got before we go to the 6th, now it's the 6th of December, the final negotiating mandate. So from where I'm seated, all these issues, and the department is on the 6th of December. There's just a revised schedule that they've actually sent now. The final negotiating mandate is 6th of December. From the 24th, on the basis of all issues that have been presented there, you still have a week or so to actually look into them and go again for the second round on the 6th of December for final mandate. The other issue that has been raised, I think here is a repetition, temporary use of expropriation, the agent expropriation. We have qualified it, but I think they were raising to say that it might be open for abuse and others might be wanting to manipulate it. But in the bill itself, we spoke about a year, and they were raising the question of saying, why are we not actually following the processes that are followed in the normal expropriation? And why do we just actually identify only the natural disaster? Because there might be other activities that warrant us to go for agent expropriation. So what do we then actually do in that particular scenario? But when we coach it on the basis of unforeseen circumstances, and we gave an example of the natural disaster. If there are others that perhaps could actually be raised, Chairperson, you still have the opportunity to do that through the NCOP. The delegation is not covered by here. It was covered by race relation. The Valuer General is not actually covered here as well. I think they spoke about the role played by the valuers, and the state being instrumental in terms of actually appointing the valuers, to say that perhaps they might actually be, because as currently we're sitting with the problem with the expropriation for ESCOM, and for a lack of better word, some valuers are colluding with the property owners, and as such, it's actually dragging the process of actually finalizing the amount to be compensated, because you'll find your land affairs board has made a determination on the particular value. The private valuers outside, appointed by the property's owner, they're coming with a different value altogether on the same property. And remember, these are professionals. One would not actually expect, even if we're allowing a degree of discrepancy, it can be 1 million and somebody else is saying 25 million. You could see the discrepancy there is quite huge. And some of them have been brought before the tribunal to actually look into this matter because their ethical conduct are not in line with what is expected of them. So, and the Valuers Act of 1914 also 2014 assist us in terms of that particular issue. Chairperson, I don't want to talk much about clause 12.3. I think, it's also covered here comprehensively. And the rationale is also given in terms of how, as a department, arrived to clause 12.3. Remember, the bill that was not actually signed into law by President, it did not actually have clause 12.3. It was just a different bill, but speaking to the repeal of 1975. Then, there was a process of trying to actually, amend Section 25 of the Constitution. It did not actually, fly on the basis that there was no necessary majority for it to fly. So the clause 12.3, which talks about nil compensation and is not exhaustive, is coined around Section 25 of the Constitution as it stands. Because yes, there are a lot of scholars and other lawmakers and constitutionalists who said Constitution as it stands, Section 25 allows for nil compensation to be paid for expropriation. But Chair, I agree with you to say that times there are this contradiction to say, how do we then actually arrive at zero when you have actually, evaluate a property and so on and so on? Then that's where you'll find we'll be talking about abandoned. And then you'll ask to say, what do you mean by abandoned? And then they'll be qualifying it further and say there are other properties that we can actually give you an example of that. The owners are no longer where to be found. There's nobody, even if you could actually put it in, in mass media to say we want to know the owner of, they are not actually coming forth. So those are the property that we're referring to. But like you're saying, if it's not clear, then it will have these questions and so on and so on. The question of the buildings in the inner city that are also posing health risk and so on and so on. The recent example of Johannesburg. So it's just that in the bill itself, when it's flagged, that's why the advice that we got was to say that I think civic education is actually needed, particularly in this bill, because a lot of people are not actually raising what the bill is covering. They are raising some of the issues that are not actually covered by the bill, but they are quite genuine because the bill is vague and it's ambiguous. So if you try to clarify these areas that are vague and ambiguous, perhaps the understanding by people and also the entire population of our country to be better. But Chair, like I've said, in terms of clause 12.3, I don't want to know there's a body of answers that have been actually flagged here. I'm not going to actually focus in terms of that. It's before the NCOP. The NCOP will make a final determination. The constitutionality of the bill in relation to 12.3, I think it came as well, and here in this context was raised by the race relation. And they were also suggesting to say that perhaps before it goes to the National Assembly for the adoption of the report of the NCOP, maybe let's test it with the Constitutional Court and see. And they were saying the state should actually, sponsor the financial obligations that are going to be incurred on the basis of that, so that we could be very, very sure. The issue of the labor tenant as well, Chair, we have covered it here, and then it came as a result of the input that were actually reflected in the NC and in the National Assembly processes. I think we have got about 72 issues that have been covered around that. I'm not going to, if you're ready, I might actually finish around 9 o'clock. So I'll provide the documentation and look into that as well. Same applies to interest of secured creditors. That's BASA thing. We have about 91 issues that were flagged around that to qualify that one. We'll send it to you as well. So it will take time if one will actually go through that. Expropriated holder and expropriated owner as well. That's clause 12. There are issues that we've actually said we'll send the Solotam. No, it was not actually covered here. Choristry nil compensation. The principle in line with the Constitution. We have answered Agri SA, FW Declare Foundation. The other interesting thing, Chair, I won't go back to nil compensation, but there's a qualification of that. The last one is the referral to Constitutional Court, which, when we sit as a department, we have supported that to say that it could be a very worthwhile exercise to just actually check some provisions that are covered by the bill, whether they are actually meeting the constitutional muster. And we said it's just a view as a department of us as a department, and the NCOP can actually make a final determination to actually do that. Abandoned land as well, we spoke about it, and we flagged about, I think, it's 137 issues that you need to cover. Compensation possession is about, I think, 70 transfer required ownership. So, Chair, let me say I'm gonna email that, but it covers all those. The only thing that is not actually covered is what has been sponsored by Stellenbosch, I think, by Professor Thuli Madonsela, in terms of changing the socio-economic impact assessment, the tool that we're using, because some of these things we should have actually detected them long time ago and debate about them and don't find expression in the bill itself. The bill is so advanced, and there are issues that we seem not to be very sure of. And she was saying perhaps, we need to actually look at that tool and see as to whether it could actually be possible for us to detect some of the things before they could actually be so advanced. So
Okay,
I'll forward those responses to you to actually.
But the most important one for me, and I think for the members, it will be that working group report that you said they are busy with. If we can get that before we formulate our final mandate, that will be helpful.
When are you anticipating to finish?
The negotiating mandate, we need to send it by Wednesday.
By Wednesday.
The
Let me
negotiating
see what I can do. I'll try to check as to whether how far have they gone for now.
Okay,
So that
we'll appreciate that. It will help us a lot too.
But also this one, I'll send it to you as well,
All
because it's just a response to those vertical issues that have been raised.
Okay. Okay, members, we do have now, thank you, Mr. Ndu. We do have the matrix from the public hearings, which is this one. Yeah, we know that you were there. Okay, let's go through the first one was the Mossel Bay municipality.
Are we projecting that?
Pardon?
Are we projecting? Oh,
Yeah, Shumis will project that. Do you have a copy? No, you don't have a copy. It's blue. Okay, members, before I start, what time is our end time? What time do you want us to stop for the day? Yeah. It's a very difficult question. Oh, you're still caucusing? What time do you want us to talk to me on the mic so that if you can try to do it quickly? I know you're tired.
Well, no, Chair, I was just looking at the notice that you gave us. That the meeting will be from 9 till 3. That's the notice that we have received. And I've also saw something, Chair, I'm not sure, that everything that we did not finalize today.
Okay, no, there's no way we can finalize today. So if that is the case, I've requested Mr. Ndu to extend this day for tomorrow, so we can break now and then we can start with this in the morning and just after do the negotiating mandates. If you are in agreement for that. I think also Mr. Ndu is very exhausted because he has to talk to each and every submission that we have here. So members, we are going to change the program for today. You'll get the notice that the meeting will start 9 o'clock and then we'll end 4 tomorrow, so that I don't get to be quoted that I said from 9 to 3. So I will extend to 6, in fact, from 9 to 6. Because tomorrow we don't have an option. We have to, until we agree on our negotiating mandate, so that you don't say I'm going because of members Lekus.
Yeah, Chair, I just want to say I support your proposal that you take it from 9 until 6.
Yeah, okay.
So if we finish earlier, it's a blessing. Thank you, Chair.
Okay. So tomorrow we will do from 9 to 6, Shumis, the notice, because we have 2 submissions for the negotiating mandate is the 15th, which is it's Wednesday. So we don't even have the option. We have to make sure that we do that. And Lizette and Shumis, they will have to create miracles throughout after we are done tomorrow for it to be ready for Wednesday to be submitted. With that being said, Advocate Masdorf, suspend. Mr. Andrews, thank you very much for being with us. Tomorrow is a new day. I came rocking like a well, on a Monday, but you know we save. And members, thank you very much for your help for today. Lizette Shemis, Nakoti Masinhle. Thank you very much. The meeting is adjourned. We'll meet 9 o'clock in the chambers tomorrow. Rest and let's take off where we left today. Thank you.